start. I'll ask the team at the communications desk to play the national anthem so we can be upstanding, please, for the national anthem.
Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tuilinde, tuajirike, tuimarike, umoja wetu ni nguzo yetu, idumu jumuiya yetu.
Thank you very much. You may have your seats. I don't have the protocol yet, but allow me to acknowledge notable guests in our midst. We have the President of the East African Law Society, Mr. Ramadan Abubakar. We have the Chair of the Kenya Law Reform Commission, Ms. Christina Gimba. We have the Director of the Law Development Center, Dr. Pamela Tibihikira, and we have notable deans of faculties. We also have Dr. Thionkolu, we have Mwalimu Elisha Ngoya, among others. So, ladies and gentlemen, good morning. And I wish to welcome you to day 3 of this conference on the future of legal education. Today we have a good day with different panels coming up. The first one is a high-level roundtable on the future of legal education and national and regional development. And subsequently, we have paper presentations. But before we get to that, we have apologies of those who are running late, including the Council of Legal Education CEO and the chair who will be joining us. Later on, we will give directions on how and when we will close the conference. For now, allow me to give a recap of day 2 of what happened yesterday, especially for those who are not here with us yesterday. Yesterday, we had a couple of discussions. During the first discussion, which was a panel on redesigning future-ready curricula, which was the opening sessions, we had a few highlights, and some of the outcomes are that the future of legal education is flexible. We need to phase out rigid curricula, and we need to find, we need to move, there's a global shift, from paper credentials to solution-driven competencies aligned with industry needs. We also got some key takeaways also is that technology and human elements must coexist. There was also one of our panelists who is the director of NCIA, Nairobi Center for International Arbitration, who emphasized the need to have ADR incorporated into the curriculum, and noted that international arbitrators are often non-Kenyans, so there is need for us to improve our curriculum to ensure that our members are also participating in international arbitration exercises. We subsequently had a paper presented by a team from Strathmore Law School, and they gave us takeaway from the Strathmore Law School model. Some of it is that they do experiential legal learning as an independent elective course with academic credits. And this involves moot competitions, regional competitions. We have national competitions, legal aid, caravan, legal clinic leadership, among others. They also talked about structured attachments throughout the program, and the recommendations that they gave were that we should explicitly recognize experiential learning in curriculum, include experiential learning as mandatory graduation requirement, and develop assessment frameworks as well as recognize prior learning. The key highlight of the day was the speech by the Chief Justice of the Republic of Kenya, who is also the President of the Supreme Court of Kenya. Takeaways from her contribution was that the role of lawyers is changing, and public expectations are rising alongside global and regional changes, and that justice is also undergoing a profound shift to a people-centered approach. And justice is not now only in courtrooms, but also it is a lived reality, and the change then must begin in the classrooms so that it can grow into what she called the people-centered justice. She highlighted that she admitted 920 new advocates in the last, I think, about 2 weeks or a month or so. And all were trained, examined, and found fit and qualified to be admitted. And there was no justification to reduce the numbers of all those who are qualified. And therefore alluded that we cannot be gatekeepers because we became advocates ourselves, and we cannot now sit at the gate and say so-and-so cannot gain. Anyone who is qualified should be allowed to join the profession. And therefore the solution is not in limiting the quantity, but addressing the quality problems. She gave an example from India, where she compared the human population versus the number of advocates, and suggested that we need technical solutions to real problems, which are quality, and therefore open up opportunities for advocates in many areas of the law. The challenges that she identified, there are gaps in the curriculum coherence, challenges in pedagogical nature of the legal practice and the new competencies, and mentioned that in terms of globalization and regional integration, there is accelerated mobility of commerce, capital, people, and ideas. And the regional integration under the East African Community and African Continental Free Trade Area calls for expansion of cross-border. There's expansion of cross-border commercial transactions. And in terms of technological transformations, digital technologies changed how justice is accessed, evolution in how crimes are committed and evidence gathered, and there's also a rise of complex financial crime, including money laundering, terrorism, financing, and cybercrime. And therefore, the new competencies required for lawyers include financial intelligence and risk management, compliance frameworks, cybersecurity and digital forensics, international commercial law, trade investment protocols, and arbitration. And the profile, she described the profile of a globally competitive lawyer to be one who is agile and adaptable, globally literate, technologically fluent, ethically grounded, and capable of navigating intersecting legal systems across borders and jurisdictions, and finally, understanding not only the law, but the ecosystem where law operates, society, technology, markets, human behavior, and changing justice dynamics. We also had other panels coming in. We had a presentation by the Deputy Solicitor General, representing the Solicitor General of the Republic of Kenya, and her takeaway was that traditional approaches are no longer adequate. I think this is something that has been echoed over and over. traditional approaches are no longer adequate for contemporary demands. And the Office of the Attorney General is establishing a training chamber for virtual and physical learning for in-house counsel, and the training programs on ethical use of AI, Working Committee on Legal Education Sector Reforms established in 2024 is already implementing the recommendations with statutory reforms underway. And finally, that pedagogy not only is not taking interest in public lawyering. Pedagogy is not taking interest in public lawyering, and therefore they need to do that, and CLE should benchmark. We did have voices from the bar, a team of lawyers from the bar who also who came to give their views on legal education, and they were of the view that philosophy of legal education is unclear and undefined. And until education and regulators fully understand the legal sector, training will continue to be based on misplaced priorities. And they also emphasize the many emerging issues that cannot simply be taught to students to learn independently. Some of these include entrepreneurship, and that entrepreneurship should be, as a matter of fact, be taught, incorporated into the curriculum. They also say that there is a disconnect between training and market expectations, and which is a philosophical problem. And law schools exist to produce entrepreneurship, but they focus on, instead of focusing on entrepreneurship, they focus on pushing careers to market which creates a mismatch and frustration, so that whatever you're trained for is not necessarily what you find in the market. And also the need to have the students develop communication skills, which is a necessary ingredient for any lawyer. And finally, that theoretical knowledge alone does not equip students with lived experience required to practice, and therefore there is need to converge both theory and practice. We also had a session on emerging areas and regional perspectives, and there was discussion on devolution, challenges stemming from insufficient legal capacity within the country. There was also a discussion on AML, previously existed as a standalone at the university, and there is encouragement to have it returned. I think this was the University of Nairobi, into the curriculum as a standalone course. Professor Moni Wekesa talked about examination and called for use of multiple choice questions in legal education. The last panel was on the regional perspectives on AML, and we had a representative from Makerere University who proposed that AML teaching be embedded within existing modules, particularly law and legal profession, especially since AML is an emerging area. And as opposed to what Dr. Moni said, his proposal was that it should be embedded into the curriculum, not as a standalone, but among the available courses. And that legal clinics, public interest education clinics, modules on sexuality, gender and the law, moot courts programs should also be taught. The University of Dar es Salaam, Dr. Cecilia Ngaiza. Universities in Tanzania offer different defined LLB structures. The Tanzania and Uganda share a two-tier system combining the university education with the professional qualification. And in 2009, Tanzania established a Bachelor of Arts in Law Enforcement for police officers and secondary graduates. And this program accommodates AML content, anti-money laundering content, through psychological studies, crime investigations, cyber crimes, and transactional crimes and modules. We also had Dr. Laila Latif from University of Nairobi, whose recommendations were that the OECD level Eurocentric AML recommendations at OECD OECD level Eurocentric, fail to account for African context, and it is a responsibility of the African scholar to develop policies rooted in continent realities. Finally, we had David Sigano from East African Law Society, who said that leading ESC law schools do not offer specialized AML courses, and ELS provides continuous CPD to lawyers across the region, and that CPD includes the AML and CFT area. The key takeaways, therefore, are that we prefer quality. The voices of those who spoke yesterday say that they prefer quality over quantity. In terms of legal education, we should focus on ensuring that there is quality in what is taught and therefore quality in what is produced. The other takeaway was that curriculum transformation is urgent. I think this cannot be gainsaid. And there is no need, there is a need to move from the rigid to a flexible student-driven learning. And I think also in view of the upcoming CBET curriculum that is catching up with us in another 3 years, we need to work on that. They also take away that ethics and integrity are non-negotiable. They must be at the epicenter of legal training. Technology and human balance are critical. Competency-based experiential learning is also essential. Regional harmonization and global competencies to facilitate free movement of legal services within the East African region, and therefore call for mutual recognition frameworks is needed. And then practical skills integration in the curriculum. In terms of AML and CFT, this was debated, whether it should be a standalone in the curriculum or should be embedded. I think this is for the legal education providers to decide, because I think it works either way, whether you embed it within the subject or you teach it as a standalone. Then there was also need for stakeholder collaboration among the bar, judiciary, industry regulators, development partners. We work together to build stronger bridges and ensure that the future of legal education is assured. And there is need for pedagogical innovation and people-centered justice vision. So that was day 2. It was quite heavy, as you can see from the takeaways, but we will consider all of them and see how to incorporate as part of the recommendations that come from the conference. So for now, we move on to the main conference itself. According to the program, we have a high-level roundtable, which I want to hand over to Mwalimu Elisha Ongoya to take over and introduce his panel. So we can clap for him as he comes over. Thank you very much. Karibu sana. I can take.
Thank you so much, Director, and for that recap of yesterday. I have a panel that I'm going to call to the stage one by one. I hope that the technical side has supplied us with the microphones. It's free sitting panelists as you come over. The first panelist that I call to the stage is Ms. Christine Agimba. In summary, Ms. Agimba is the chair of the Kenya Law Reform Commission, but I know her. She has an illustrious career in public service, and she's certainly one of the best placed persons to engage us in the conversation. Let's clap for her as she goes to the stage. The second panelist that I call to the stage is Dr. Muthomi Thiankolu. Dr. Muthomi Thiankolu needs no introduction. He's an advocate of the High Court of Kenya of repute. He is a partner at Muthomi and Karanja Advocates, and he has, for the longest time, been teaching law at the University of Nairobi School of Law. The third panelist that I call to the stage is Mr. Ramadan Abubakar. Let's clap for him as he comes kindly. Mr. Abubakar, over and above being an advocate of the High Court of Kenya, also serves as the president of the East African Law Society. When we talk about matters of regional development, that body cannot be wished away. And the fourth and final panelist for this morning is Dr. Pamela Tibihikira Kaliegira. I hope I got it right. Thank you. Thank you. She has an elaborate CV. She's currently the director of the Law Development Center in Uganda. I was telling her yesterday that I teach Ugandan students here, and they tell me they cross the border because their things are tougher. So they cross the border where things are easier. She has previously served as the chair of the Uganda Law Reform Commission. She was also the first director of quality assurance and accreditation at the National Council for Higher Education. And she has also served as the Dean of the Faculty of Law at the Uganda Christian University, among many other accomplishments. So allow me to just set the ground rules. Our time is far much spent, just like yesterday. I'm advised I have 50 minutes to finish this panel conversation. So because of that, and to ensure that every panelist has equal opportunity to give us their thoughts, I'll frame out the issue for every panelist and give them 10 minutes to give us their broad thoughts. That will consume 40 minutes. Then I'll give the plenary some 10 minutes to engage the panelists in a question and answer session. So let me take one of those minutes to take my seat so that the panelists can engage us, but they'll engage us from where they are seated so that we don't waste a lot of time moving to the podium and back. So our theme for this morning is the future of legal education and national and regional development, the sub-theme being setting standards and harmonization of legal education for cross-border practice. The first panelist that I want to give the opportunity is Ms. Christine Agimba. And because of Ms. Agimba's experience in public service, I desire that she addresses the need to train lawyers who are ready for public service, at least from her experience. And to do that, I urge her to paint for us the picture of the need or the problem, to see if she, in her illustrious career, has identified curriculum gaps in terms of addressing that needs, and to address what skills lawyers need for public service. Are there skill sets that we who develop curricula, who implement curricula, may need to focus on in terms of preparing lawyers who have adequate skills for public service? Then, if time permits, what are the opportunities that she has identified available in cross-border practice, and what skills do lawyers need for cross-border practice, and are there curriculum gaps that she may have noted in the endeavor to equip lawyers with those skills? Over to you, Ms. Agimba, 10 minutes.
Thank you very much, Elisha, and good morning, everyone.
Good morning.
Let me start off by saying there is no doubt in my mind that competent and knowledgeable legal professionals are critical in national development. And when we are talking about national development, we then have to reflect on the roles and responsibilities that national governments have. And national governments have a range of roles. Essentially, and speaking as lawyers, they have the critical role of making sure that we have predictable, harmonized legal frameworks and a functioning legal system. And this is so that government can then manage national resources well. Governments can attract investment into the country and ensure that they deliver as per their political manifestos and mandates in the case of the executive. And public sector lawyers play a critical role in this. And I think we talked about this over the last 2 days. When we say that lawyers have a role, transactional and advisory roles, when we say that lawyers are gatekeepers, those are roles that are played also by public sector lawyers. Public sector lawyers are responsible for negotiating complex agreements, managing complex relationships with various partners, handling and managing complex dispute resolutions. Government lawyers, in doing what they do, are responsible for taking into account the public interest. And I think this is a role that's always pointed out to particularly the Attorney General, the role of taking care of the public interest. The challenge that you then have is, and this is something I have noted in the course of my experience, is the training that we have does not necessarily prepare our lawyers for this kind of service. My experience is that training of lawyers prepares people for private practice, not for public service. And understand that public service is probably what speaks to some of the things we've talked about. The need to have ethical standards, the need for integrity, because you're in a space where you're protecting the public interest. So this is very, very critical. When it comes to national development, I think you will agree with me that very often governments have to bring in other I'll call it other professionals to provide the legal support that they need. And the reason for this, I think, clearly demonstrates that there may be a problem of disproportionate legal capacity within our countries. And therefore, when governments are negotiating or handling transactions with investors who've enlisted lawyers from the big international law firms, you have to then bring in support for your internal capacity. And the question that we must ask ourselves is, what is it that causes this proportionate legal capacity? Is it that we don't have the knowledge? We don't have the specialist skills? Is it that we don't have the right attitude? And if indeed we are aware of the gaps and the challenges in being able to provide the level of legal expertise that's required, what are we doing about it? I think the conversations over the last 2 days have reimagined that we need to rethink our approaches to training, and much of the focus has been on the training at the undergraduate level and at the advocate training program in the case of Kenya. And I'd like to say that my view is that when it comes to training of lawyers for public service, there's need to rethink how we undertake professional training post-qualification. The biggest challenge that we have is that we are aware that there are these gaps and challenges, but nobody seems to want to bridge this gap. I would admit that bar associations have tried, in the case of Kenya, through the CPD programs, but I don't know that these actually respond to the needs and the requirements that are needed for the level of legal professionalism that's required. There is a gap. There is something that needs to be done. And I'd like to point out that the fact that there is a gap is demonstrated by the establishment of institutions like the Kenya Judiciary Academy, or the fact that the Office of the Director of Public Prosecutions has established their own training institution. This is probably in recognition that the training that we've spoken about is not adequate, and there's need to address these gaps post-qualification by coming up with the training institutions. But this doesn't address the needs of a range of other legal professionals. And I dare say that institutions like the Kenya School of Law and our universities have a key role in making sure that they think through how they support professional training at this level. I don't think that we should leave this to the whim of, I'll call it, profit-driven legal education providers. Very often and I'll speak of my experience at the AG's office, when we looked around to get appropriate training, we couldn't find it. There were probably 1 or 2 institutions in the world that provided the kind of training that was needed to support African governments as they handle their business. So there's a gap, there's an opportunity there, but more importantly, there's a real need. And we have to think through this. I'll stop there and reflect on the other issues later.
Thank you so much, Mr. Kimba, for those very insightful thoughts. And for me, as a member of one of the institutions that provides legal education service, I see that as a great opportunity. When I'm told that we can actually fashion curricula that can build capacities for institutions, even from a profit motive perspective, I see a business opportunity there. Dr. Thankolu, you will come last. I want to move to Mr. Ramadan Abubakar for strategic reasons. And Mr. Ramadan, I want you to focus on the specific issue of cross-border practice from the vantage position you hold as the president of the East African Law Society, because then you operate at that cross-border level, if I may use that word. And looking at the East African community as your area of focus, and perhaps other regional and international blocks as other areas of focus, 3 questions stand out for me. What are the opportunities at that level for legal practice? What challenges are experienced at that level in legal practice? And how can legal education and training service providers help to address those challenges through curriculum designs, through curriculum delivery, and through the skill sets that they deliver in provision of services? Over to you.
Thank you very much, Mwalimu. First, let me commence by congratulating the Council of Legal Education for coming up with this particular forum. This is an important conversation to have, not only with the bar, but also the providers of legal education in the nation and in the region. So kudos to the Council. As East Africa Law Society, cross-border practice is one of our mandates. When East Africa Law Society was established in 1995 by the founders, one of them being the Chief Justice of Kenya, who was the inaugural treasurer. And the dream was to have a lawyer in Kenya being able to practice in Uganda, a Ugandan lawyer being able to practice in Tanzania. But for 30 years, this dream has never been actuated. Some progress has been made, one nation or the other. Specifically, let's say for Kenya and Rwanda have made great advancements in terms of harmonization of their laws to allow practitioners from across the region to practice here in Kenya. Specifically, Section 12 of the Advocates Act in Kenya is of relevance, which allows at least advocates from Uganda, Tanzania, Rwanda, and Burundi. But the courts have also expanded this provision. In a recent case that was done this year by the Court of Appeal, which I advise that you read, the case of Council of Legal Education versus Tusasirwe. In this particular case, decided in March this year, the South Sudanese students had challenged because Section 12 did not have South Sudan. And we all know South Sudan is part of the EAC. They successfully challenged this provision, and the Court of Appeal said, by virtue of the EAC treaty, it would therefore mean Section 12, the countries in the region are allowed by virtue of the treaty. Therefore, South Sudan, by virtue of them being a partner state, therefore, the Council of Legal Education must therefore admit lawyers from South Sudan. This is progressive from where I sit, and this is what the region should follow. I'll tell you a case of Rwanda. Rwanda has also advanced in terms of cross-border practice. But when there were challenges in admitting Rwandese lawyers here in Kenya, they closed their doors. They said, okay, if Uganda is not admitting Rwandese lawyers, Tanzania is not doing the same, then for us, our argument now going forward, they amended their laws and said reciprocity. Admit Rwandese, we admit Kenya. Admit Tanzanians, Tanzania to admit Rwandese, Rwandese to admit. So reciprocity is the argument in terms of Rwanda. Therefore, challenges are there. And recently, I'm sure you also, what happened in Uganda, and I'm happy Daktari is here. Perhaps she can also speak on this. When Martha Karua Senior Counsel attempted to represent her client, Dr. Besigye. And of course, an issue of a practicing certificate was brought up. That first, issuance of the practicing certificate was a problem. When the Supreme Court rendered that Dr. Besigye cannot be tried in the courts martial. And you remember, she was granted a practicing certificate in that particular, after push and pull by East Africa Law Society and the Uganda Law Society. So she was granted a practice certificate eventually. But when the matter was moved to the other conventional courts, then it became an issue again. But as East Africa Law Society, just to summarize, we also sued the Attorney General of Uganda because it was in breach of the treaty in terms of free movement of legal services. So the matter is still pending before the ESCJ because we are questioning if we're talking cross-border practice, when is this going to happen? That's the question. But in terms of where we sit as East Africa Law Society, we shall never cease pushing for cross-border practice. I'm also happy that as legal educators we're having this conversation because cross-border cannot happen without harmonization of our laws. Because it begins at the student level. I don't know in terms of from the room, how many had a chance to study EAC law? By a show of hands. EAC law. Very well. That's a good number. But that means there's still more that needs to be done. So that sensitization begins right from the student level. Let's look at even the East Africa Legislative Assembly. Its composition. Are they, the members that Kenya, being that I'm a Kenyan, that we send to IALA, are they sensitized in terms of regional integration, or some of the members that we send there, due to political patronage, some of them are losers, or no, in terms of, they lost. They lost the elections here locally, but now are rewarded by having a position in IALA. But to me, I think these are, in terms of the law reforms that we need, in our representation at IALA, would need members who are well sensitized in matters regional integration. As East Africa Law Society, we pushed for a cross-border bill in 2014. It never saw the light. To date, that bill is still pending. But all is not lost. We have decided to revive it, amend it further to see if we can present it in the coming year. Secondly, we also conducted a report, a cross-border report, which I invite all of you to have a look. It's in our website. A cross-border report, just to see what are the challenges that are there on each and every member state. I'll tell you for a fact that in some of the countries in East Africa, they require citizenship. So no matter how much you study the law, you can never be admitted to their bar. An example is Tanzania. You must be a citizen. You must be a citizen for you to be admitted. This is in violation of the treaty. Yeah? Same applies to Burundi. You must be a citizen. So have a chance to look at the report, then you'll see how we've addressed the issue of cross-border country to country. In terms of the opportunities, there are tremendous opportunities that exist if we are to realize this dream. One is in terms of increment and bread and butter issues for lawyers. This widens the legal market. You can imagine the population in the region is about 500 million people. From the recap of the CJ speech, having admitted 920 lawyers. Yeah? So the opportunities that exist if cross-border was to be realized, let's not look nationally. Let's look beyond our borders. Right now, we have a number of lawyers in the region, which is about 45,000 lawyers. So compare this with a population of 500 million. So a lot still needs to be done in terms of even increment of lawyers, because for such a population, everyone needs a lawyer. So I think there's a chance for us to widen the legal market. There's also an opportunity to increase specialization in terms of the emerging areas in law. And so let's not see cross-border as an enemy. There's also a chance to advance our legal practice in the region. Right now, there are many firms that are doing collaboration in the region. We have Wakili Africa, we have CM advocates, that being that cross-border has not been actualized, so you have a firm in Kenya collaborating with a firm in Rwanda and the other countries in terms of opportunity for expansion of firms through collaborations. There's also a chance to expand our knowledge and reform legal practice in the region, because I'll tell you for a fact that some of the bars are older. Let me say older than the others. If you look at South Sudan. South Sudan is the youngest bar in the region, and who East Africa Law Society has been really supporting. Also with the Law Society of Kenya. In fact, we'll be traveling with the president of Law Society of Kenya just to Juba for purposes of interacting with the council and seeing areas that we can collaborate and for purposes of the members and advancing legal practice in South Sudan. So great opportunities are there. This is just a few of them, but tremendous opportunities do exist if we are to realize this dream of cross-border practice. Thank you.
Thank you so much, Mr. President. Maybe just a few observations. You know, in the run-up to the presidential election in Tanzania, I had the privilege of being invited by the Tanganyika Law Society to address the lawyers in Tanzania about emerging issues of free speech and a correct political environment for democracy. And I remember asking the president there whether I'll have freedom after speech. Because we know that freedom of speech may mean freedom before speech, or freedom during speech, or freedom after speech, or all of them. And I was the last Kenyan to ever address Tanzania lawyers. After that, you remember the Chief Justice Emeritus tried to go there, and the rest, as they say, is history. So, I mean, these are things that we certainly will need to look at as people in this region and ask, when we prepare lawyers for this cross-border practice, is that the environment that they are going to be confronted with? On a positive note, I'm happy to report that for the last couple of years, Kabarak University School of Law has been running a full-fledged publication on East African Community and Regional Integration Law as a journal. Previously started as East African Community and Regional Integration Law. Then because of this decolonization concerns, it got a Swahili name, Jumuiya. That's what it's called at the moment. It's a regular publication. It also runs a course unit on East African Community and Regional Integration Law as a course unit to try and build the capacity in the hope that it will have the desirable outcomes. Allow me to go to Dr. Pamela and seek her thoughts. We can only realize cross-border practice if we harmonize fundamental aspects of legal education, because through legal education, people get legal knowledge, and that knowledge gives them the capacity to tap into any opportunities available for cross-border practice. So how do we harmonize legal education in the region to facilitate cross-border practice? Are there existing initiatives? What are they and where are they in terms of trying to push this agenda of harmonization of legal education in this region? Over to you, Dr. Pamela.
Thank you very much, moderator. And thank you again to Council of Legal Education for having me attend the conference and benefit from the conversations that are going on, particularly here in Kenya, over your decentralization of the APT. Now, in terms of cross-border legal practice bill, which is what started this all off, there was, first of all, there was a consultancy in 2011 in the region, all the 5 countries there, to see how to harmonize our legal education. And then we met in Nairobi. I don't know who else is in the room here who met at Jacaranda. Anyone remembers? In around 2011, 2012. Now that meeting, the whole discussion fell apart because of 2 things. We went into what we thought should be the core subjects for legal education at the university level. So at that point, the disagreement came from those who were practicing civil law, that was Burundi and Rwanda, and then also Zanzibar wanted to bring in issues on Islamic law. So somehow we failed to agree. Some of us were like, okay, why don't we say these will be electives, since they're peculiar to particular regions. Then came the question of administrative law. Should it be core or not core? So we disagreed mostly on the curriculum. And it completely fell apart. We disagreed quite loudly, and since then nothing, happened. But I'm glad to hear at the East African level you're trying to revive it, because this is now 10 or more years later. Now, at the East African level, in September, Uganda hosted an inter-university for East Africa Council meeting that brought together all the East African countries to talk about the East African Common Higher Education Area, which was agreed at the partner level state sector Council of Ministers some years ago, but had never been actualized. So this September they met and agreed that we revive the conversation around harmonization of our curricula and standards in order to allow for that free movement of labor and services within the region. Once we harmonize, then we can have that mutual recognition of qualifications to allow for this. So that conversation has been revived as recent as September. And I think we here, perhaps as we have this conversation started now by the Council of Legal Education and Training here in Kenya, we need to see how we anchor ourselves with IUCA, because they have funding for this and for it to happen at the regional level. So perhaps if we say we have met and this is our outcome, I'm hoping we're going to have some statement of sorts this afternoon, we could then table that to IUCA to see how we further the conversation, because clearly some of us are missing at the table. For example, I see here this morning Tanzania is not represented, and certainly our other friends from the other East African partner states. I'll let you know that in Uganda we have agreed that East African community law must be core, so that is going to be in the curriculum for all law schools. We believe it's important and it should be adopted.
Yes, proceed to that. Yes.
Okay, so I was just asking moderator whether I could go into what we are doing in Uganda in terms of the advocates' practical training. As I said on Monday, there's a bill now which stakeholder consultation ends tomorrow, and then it will go to cabinet and then to parliament. So from what I see, Kenya and Uganda seem to have made some movement in this area. Maybe we start with the two of us agreeing on what should be within the advocates training program? Do we open it up to only law schools to provide this, existing law schools, or to also stand alone? I'm not yet sure where you are at in Kenya in terms of your draft bill that has been done by the Council of Legal Education, whether they're opening it up for other ATP providers outside of law schools, standalone. In Uganda, our current draft has standalone, but this is the fear. If you look at the UK, the solicitor's qualification exam, they allowed other providers. In fact, there are only 4 law schools that provide the solicitor's qualification exam. What has happened is a proliferation of various cram schools which are simply teaching to the test for the solicitor's qualifying examination. And so some people are being exploited because it's a money-making thing, and they're not really training, you know, the ethics bit of things as far as the profession goes. So we are having this conversation in Uganda. Should we really open it up beyond existing law schools for standalone providers? Coupled with that is our own long-term thinking, where we think at some point we are going to integrate practical legal training with the theoretical, the doctrinal instruction at the universities into having to one course where legal practice will be embedded through the clinical legal education and, you know, bring in practitioners to teach the practical bits of the theory. And that is the Indian model, where it's fused. And we are thinking long term, that is where we'll go. So one of the questions we're having is maybe we shouldn't allow standalone providers, because that will be creating a problem of stranded assets. Someone sets up a whole institution to run the ATP, and then down the road you're going to have a fused curriculum. What is going to happen to those assets, especially if government also sets up one? Like one of the conversations that perhaps the current Law Development Center should remain as a standalone provider as well. One of the other things we're also looking to do is to say there will be no online learning for the legal education and training. In Uganda this year we had 2 intakes, and for one of them we had a whole semester which was online, and it was, for lack of a better word, it was disastrous. The students were not in class. The lecturer calls upon someone to answer a question and they are clearly not there. They've logged in, but they're off. Or you hear in the background someone is in a salon or they're in the market. We just think online learning is not working for us as far as legal education and training goes. India, we discovered, the Bar Council of India does not allow online learning for legal education and training at all. They came to that conclusion very quickly, that it's not effective. This is a practical course. Students must be in class, and the ratio must be 1:40 max. I don't know what it is here in the Kenyan law schools. In Uganda, it's certainly not 1:40. I think I'm coming close to to the end of the 10 minutes. I will say that I would like to offer, given that Kenya and Uganda have moved some distance, we both have draft bills in place. Perhaps let us start there and approach IUCA on 2 grounds. One, to revive that cross-border legal practice bill, because they're who sponsored it in the beginning, so maybe with the East African Law Society we could have that conversation. And then to carry forward, agreeing on what is going to be the basic standards for us in terms of that legal education and training. Thank you very much.
Thank you so much, Dr. Pamela, for sharing those thoughts and those insights. You know, the first day when you spoke about numbers in Uganda, and you mentioned the numbers were so high, there were 7,000. I saw a paradox in it, because I was in a place where we are 20-something thousand, and I said that a lot of people who get concerned about numbers here would envy Uganda for being at 7,000. But I noticed that Uganda thought 7,000 was rather high and was a challenge they were trying to deal with. Allow me to bring in Dr. Muthomi Thiankolu, because we keep talking about reform here, and I'm inspired by the works of the great utilitarian Bentham, who spoke about reform of English law because he thought it was an utter chaos. But he said the first step towards reform of law is reform of structure of law. He thought structural issues impair the efficacy of law more than the text of law itself. Dr. Muthiomi Thiankolu has been fairly vocal on the issue of the current structures of legal education and training in Kenya. And he believes that legal education and training in Kenya is in utter chaos because of structural concerns. And that all these reforms we are talking here will come to naught until we go back and address structural issues. Dr. Muthiomi Thiankolu, therefore, take us through these structural problems in legal education and training, particularly in Kenya, that impair our capacity to, produce desired products, desired lawyers for national and regional development. Over to you, Daktari.
Thank you very much. Perhaps the first structural issue, Ongoya, is to begin with seeing how many decision makers in our legal education sector have sat throughout this workshop. I don't mean they are junior staffers. So maybe we could do a small tally. How many members of the CLE are in the room? I mean the members of CLE properly so-called. How many in the room? Okay. That is staff. I'm not talking about staff. The members of the Council of Legal Education. The board, yes. How many do we have in the room? Okay. How many deans of law schools do we have in the room? How many chairs of departments do we have in the room in any of our law schools? Oh, no one? How many vice chancellors, because our law schools are run as part of the university, how many vice chancellors have sat throughout? Not gracing the occasion, because it's one thing for a big guy or a big lady to come and grace an occasion for 10 minutes, then leave the room. How many vice chancellors do you have in the room and have been around? Okay, let me ask the last question on this, Ongoya. How many people in this room are capable of making and implementing a decision on the discussions we're having? Raise your hand if from where you sit in your organization, you are a decision maker and implementer. How many? Only 3. Yeah, I think, Ongoya, that is one of the structural problems. But if you allow me, I don't know, maybe you allow me to start. I know you forbade it. Oh, okay. He says now I should surrender the other mic. I don't know whether that's a structural issue or whether it is one of the other issues. But I'll focus on what I believe to be the structural issues. I must tell you, I've been following this workshop, even though I've not been here physically. And I want to begin by perhaps mentioning an individual I had many speakers mention, Professor Phoebe Okowa. I would encourage many of us to look at her CV and the type of legal assignments she has done in her career and ask ourselves, does any of our law schools offer a training that can prepare someone for that type of global career? Or would someone have, as I heard PLO suggest yesterday, perhaps these individuals are great because of other investments they have made as part of their personal career choices, not because they went to one of our law schools. There is another one I would suggest in the spirit of gender balance, the late Dr. Androniko Adogi Adede. I would encourage you to also search his CV and the things he had done and ask ourselves, do we have a law school in Kenya and in Africa, with the possible exception of South Africa, that can produce lawyers who can excel at the global stage like that? I am happy Christine Agimba is here because she said, we don't seem to prepare lawyers for public service, and I'm here to agree with that, but also add, there is no sphere of legal practice because of the structural issues I've come to speak to. We properly prepare lawyers today, not even that private practice. And I want us to ask ourselves, the United Nations has 17 specialized agencies and the Central Secretariat, all of which have very many lawyers of various nationalities working there. Do the lawyers we train, can they thrive in those spaces? The GATT WTO system is a rich area of practice, again, dominated by lawyers from Brussels, from London, from New York and Singapore. Do we train lawyers who can thrive in those spaces? Christine Agimba will not tell you loudly, but if you sit with her in a corner, she will tell you, government of Kenya outsources lawyers from London, from New York, not to do something we do with Ongoya, the constitutional division, where you have to struggle to tax your fees, but a case Ongoya, to do with, foreign trade, imports, exports, foreign direct investments, which a lawyer only needs to do one brief, Sianya, and retire. You do that brief. You don't have to do another brief in your life if all you're looking for is bread and butter. You do that one brief. And the government of Kenya, I told you, if you talk quietly off the record with Christine, she will tell you every day, including today, I'm aware of arbitrations involving government of Kenya as I stand here, going on in London, going on in Singapore, going on in Paris and other places, led by British and American lawyers, paid fees that are more than all the combined fees the lawyers we envy here earn. Christians, you guys may say uongo, but I won't ask you on the... So for me, these are the structural issues. One of them is this magic called Kenya School of Law. Kenson and I had envisioned Kenya School of Law like one giant sieve, the one we used to filter tea. And from this sieve, we feed tea from our about 20 law schools, because the assumption is that the law schools are doing a bad job. And I'm here to ask, what is this magic the Kenya School of Law has, that it is able to take students from KU, from Quer, from UN, from Strathmore, I could go on, presumptively because these guys can do a good job. They don't have the student-lecturer ratio, they don't have the libraries, they don't have all these things. But somehow KSL has the magic. It is capable, one institution, to absorb all these guys and take care of their training shortcomings. Does Kenya School of Law have a student-lecturer ratio that is equal to the combined student-lecturer ratio of all the law schools? Does Kenya School of Law have a library capacity that is equal to the combined library capacity? Does it have faculty that is equal to, I don't know, that is one of them. I could go on and on and on and on. The other structural problem is our legal system speaks only to a very tiny majority of the Kenyan population. Most legal issues, whether they are transactions, whether they are deals, whatever you call them, whether they are disputes, take place outside of formal law. Most disputes are resolved by elders, by relatives, by chiefs. Many at the police station, they don't reach the court. Many deals are sealed even using traditional oaths. There is a joke on Goy in Meru that if you want a man to speak truthful on oath in Meru, you take them to the Jurincheke. They can't lie on oath when they have taken the oath before the Jurincheke. But if you bring them before the Supreme Court of Kenya, they are happy to take whatever oath. And they'll be looking at you straight in the eye and saying lies. We have a curriculum that was meant for glorified home guards. You know, the so-called core subjects. I've heard that phrase even mentioned here. Can those core subjects, we have even codified them in law, produce a Phoebe Okowa? Can they produce a Dr. Adroniko Adede? Can they produce lawyers who drive in all these pieces? Or is it a curriculum that was designed under the Lord Denning report, envisioning, Kenya and Africa as just outposts of the then dying colonial or the British Empire, playing second fiddle on the margins to lawyers in London as the main players? That curriculum can only train Jogoo wa Shamba. They say Jogoo wa Shamba wiki mjini. So we have this global market, and how I've envisioned it, Christine Agimba, I hope you love this, is that the global legal market is a big ocean, like the Pacific, like the Indian Ocean. And in that ocean, of course, we know it has very many resources of various types that we fish there. But the lawyer we train is not equipped to fish or to exploit the marine resources in that huge water body called the Indian Ocean or the Pacific Ocean. They are trained to drive in a small pool, a small pod, a fish pod. And for, of course, those who practice law of the sea, that metaphor is accurate even in the literal sense. You have Japanese vessels shipping on Kenyan territorial waters, Chinese vessels fishing on Kenyan territorial waters, and our fishermen are some small boats, wood-paddled boats. So to me, the structural problem, Mr. Ongoya, the world is a global village. We produce lawyers for our local village called Milimani High Court, called Nyeri Law Court, called Kisumu Law Court. It is Mr. Nelson Avi who says, if you go hunting, and then there is an elephant and you're focusing on a squirrel or a rat, there is an antelope, you've gone hunting. We train lawyers to hunt in a market for legal services. We have the whole world there, but we train them for a small fishing pod of 10 by 10, when the UK, the Americans, and the other serious players, of late even the Chinese, are training their lawyers to fish in the big oceans. Those big oceans, I said, they are WTO, UN, ICSID, ICC, ICJ, EACJ, COMESA. I could go on and on and on and on. Somebody has mentioned virtual training, online training. My experience as a lecturer at the University of Nairobi has been worse. My student has logged in class, so the screen shows me student called Mudhomi Dienkolu is logged into class. Only for me, Professor Mwimeli, when I call out that student who is logged in, and when it turns out they are making ugali in their kitchen. And sometimes they are making other things that I don't know whether will be in order. We administer online exams with zero safeguards. So I have no way of knowing whether it is the candidate doing the exam, whether they are using the World Wide Web or these days AI to generate the answers, and whether they attended class, we also can't know because of the other thing. Then we have taken it to online court training. I now have a generation, Jack Mwimali, I swear I'm not making this up, of young men, young women who have just joined the profession. They attended class virtually. They sat exams virtually. Now they practice law virtually. This guy has never met Professor Sianye in the real world in a physical. He has never met a real lecturer. Never met a real advisor in court. Never met a real judge. And what has been happening is, I thought Ongoya, when we go before those sessions, you and I go to speak, for me, Kim English, for you, Luya English, there is a lot that shapes us based on actual, real interactions with real human beings. And I don't know, when I've checked other countries, there are safeguards for doing online exams. We have none here, but we pretend we are doing online exams. The more serious countries have safeguards for online teaching. Here we have none. It is online teaching. These days I've seen even lawyers, Ongoya, you know, my lord, my camera is this, and they just switched it off to coach the witness. I've seen witnesses with headphones and whatever. Somebody is whispering to them the answers, but of course the device they're speaking to is the different one. What I called in my post, Jack Muimali, what happens between muted microphones. That's one of the structural issues. I don't know how we address it. In the universities, why I asked whether there are deans here today. I think Ongoya wanted me to speak last because I'm the guy who speaks badly. But it's okay. The law school of today in Kenya is the cash cow for the other schools of the university. Ben Sianye is here. If he's a man of the truth, he knows what I'm saying is true. That is why I had Avi ask you yesterday, why is there no similar exponential growth in the number of engineers, in the number of doctors, in the number of architects, but we have this implosion of law students and law graduates? It is because the typical Kenyan university, where I asked whether there are vice chancellors here, with decreased government funding, with the hard economic times, the law school, because it is cheaper to train a law student than it is to train an engineering student, than it is to train. So what they do, because law has some social prestige, is open law schools everywhere, so that they will collect money to subsidize how to run the engineering school, how to run the architectural school, how to run the business school, but that money is not invested in improving the quality of education in the law schools. Parklands, why I have taught. You know, sometimes we joke too much on Goya. You know, Parklands Law Campus, where I've taught for 13 years, is the school of law. It is the oldest. It is housed in premises that could not pass a human's occupational and safety audit. Yeah, that school has generated most revenue to the University of Nairobi. I can say that without any fear of contradiction. In the last 20 years. It is still, if you go to the hostels, they were last repainted. I swear I'm not making this, in the 1980s or 1970s. If you go to the student bathrooms, they have years-old limescale and grime. If you go there, going to shower there is an health hazard in that bathroom. I have seen podiums there like this one, Nongwea, the lecturer's podium. It is broken and it is supported by a piece of wood. So if it slips, the whole thing and my laptop, everything falls all over. I've seen staff toilets stinking. Not forget the student ones, the staff ones stinking and leaking. And when you do the math, this law school, because of the ever expanding programs, has collected billions, not millions, for the university. in the last several years. How did we get there? To me, that's one of the structural issues. When Kenson and I were thinking about this, there is a joke in Spain, Ongoya, where they say the Republic of Spain is like a cow with its mouth in Catalonia and its udder in Madrid. So this cow feeds the pastures in Catalonia, but the milk goes to Madrid. And I dare say that today's Kenyan law school has its mouth, today's university has its mouth in the law school, and its udder in the other schools. The law school is the one subsidizing monetization of degree programs. Because of a silly policy we had, and Christine, I'm happy you're here. I see Ongoya telling me I've said enough bad things. Is that so? So that I can just take my seat? In this country, we love degrees and titles. So we will be promoted if you have an LLM, you'll be promoted if you have a PhD, you'll be promoted if you have a higher degree, higher diploma, and whatnot. So we have students enrolling. We interpret this market flaw. In economics, they call it a market imperfection. We interpret it to be demand for legal education and training. Whereas the student has only come so that they will, once they get the degree, get a promotion at work. As a result, our completion rates, especially for postgraduate studies, I dare to be contradicted. Professor Sianya is here. They are less than 1%. A master's program should last a year. I have seen at the University of Nairobi and other places, people who have been on the LLM program for close to 20 years. They never complete. The last Ongoya, because you said I've spoken very many bad things, is the quality of students. I was showing Christine Agimba. And on Professor Sianyas, there is my witness. How many times we have an essay, a project paper, a dissertation, a thesis written by a student and signed off by a professor of law, in which the candidate has hundreds of spelling mistakes, where there is no subject-verb agreement. Things we were taught in Standard 4 Ongoya through a book called English Aid. Standard 4, 4th grade. Where they are missing full stops. Not one or two, but several of them. Where they are missing commas. Where there is use of informal language. This is not an undergraduate student we are talking about, Ongoya, but a student who has passed the third part of the master's or the PhD. And there is a professor that assigned that I have read this project and I certify it meets the minimum requirements. Just last week, Ongoya allowed me to add by reading an email I sent just last week to the University of Nairobi when I was asked to examine an LLM. This email was sent on the 13th of November, 2025, and it says, the reader, that is me, made a genuine effort to review the manuscript and the reference, but was unable to do so. After genuine effort, as indicated in the attached version with track changes, the manuscript contains numerous grammatical, spelling, and formatting errors, including missing full stops and other punctuation inconsistencies, spelling mistakes, irregular spacing between words and paragraphs, inconsistent line and paragraph alignment. It appears the candidate did not conduct even a basic spell check before submission. In addition, the manuscript does not adhere to a scholar or any other recognized referencing or citation style. The above deficiency significantly disrupted the reading experience, and the logical flow of the argument, making it impossible, underline impossible, Jack Muimali, for the reader to engage meaningfully with the candidate's ideas. The reader therefore concluded that the manuscript is not ready for examination. This is a candidate who was an LLB, who was taught legal research and writing, who was taught referencing, who was taught all these things, and they passed. And they did not only pass, but they passed so well that they were eligible for the LLM. And this LLM now we are marking with these issues. Sianya, please confirm how many times I have sent similar emails. You agree it's countless times, true or false? You know, you and I have discussed these problems. That is the quality of student that comes to our law schools these days because there is a demand for legal education and training. God be with you.
Thank you. Thank you, Dr. Mudomi Thiankolu. I was seated here and I was wondering why I didn't have the powers of the Speaker of the National Assembly, because what he does is the microphone is normally switched off. Then you can continue talking if you want, but the microphone is off. So that's a struggle I had as I sat here. But the plenary, you've had your panelists. Since our time is far much spent, I would want just to pick 2 questions from plenary. So from the plenary, so that we have our panelists respond to them. I can see one hand up there and another hand there. I want to stop at those 2 hands. No, there's a 3rd hand. I'll pick that 3rd one. So there's a hand. My eyes are very bad. There's a gentleman. Yes, that's Professor Amwara, most likely. Then there's a hand here. Yes, that's this one of yours. Next, sitting on Professor Zehanya's table. Then there's a hand there. Just those 3 hands. We'll take all the questions together. Then I'll have my panelists respond. If you can specifically point out the panelists you want to respond, I will highly appreciate. But if you don't, I'll do the best I can with your question.
Thank you very much for the wonderful submissions. Dr. Thiankolu, I am bringing a discussion we had online here. And I'm asked 2 questions. One, how much have you done other than write the emails to try to change things? I have this theory where I'm saying if I am in a place, I have to be fully there. And that means if I can't make any changes, then I should leave. What have you done internally other than write the email? And then the last thing, of course, is, are we not sometimes forgetting where we have all come from, especially when you don't engage the ideas because you think the English is too peripheral or pedestrian? Thank you.
Thank you, Prof. Amara. The second question was on this table, yes?
Yeah, thank you. I want to appreciate the presenters. They have done wonderful work. My question goes to Dr. Mudomi. You have indicated that the quality of the students we have is disappointing, and really that is, I think, one of the main structural problems. But I also want to add that even some of the lecturers we have, especially the former GNCs, they almost belong to the same group with those poor quality of students. The question is, how can we improve the quality of the students we admit to law schools? Thank you.
Thank you so much, Daktari, for that. Dr. Mudomi, you brought yourself problems. You'll have very many questions to answer. There's somebody, that's Dr. Mbori?
Yes.
Thanks a lot.
Dr. Harrison Mbori is my name. Unfortunately for Dr. Thiankolu, my question is to him. It's just because he was very provocative, which is always good because then you have many questions. So mine is about the quality of lecturers, and I'm a lecturer, so I'm throwing stones here intentionally. And this hasn't been spoken about at all. We haven't asked ourselves, what are the quality of our lecturers? I know now we also have lecturers who are teaching in multiple universities, and they are going from one university to the next. I know lecturers who are senior lecturers, and I've tried to check their profiles. The last time they wrote anything that is publishable is in the 90s. And I then ask myself whether this is a matter that we ourselves also as lecturers have to ask ourselves, whether we are then, how can you know, the computer analogy used to tell us when I was a student, garbage in, garbage out. Thanks.
Thank you. Thank you. I'll have CLE ask some question because CLE is here and is our regulator.
All right, thank you very much. Just a quick one, and it's following up on the ones that have already been asked. My dean, when I was in Moi University, my dean, Dr. Lugulu, used to say that there are only two species that eat its young ones, the pigs and the lawyers. Now, based on that, I would like Mr. Ramadan and Dr. Thiankolu, what is the role of lawyers in practice and in academia in bringing up, in changing this narrative that we are not doing our best, that we are not producing the best? What is our role? Whether you're in practice, wherever you are as a lawyer, what is it you can do to improve the situation? Thank you.
Thank you. Dr. Thiankolu, you have a majority of the... Oh, CLE is here. The hand is up. I can't deny CLE a chance to ask the question. So proceed.
Thank you, Mwalimu Ngoya. Mine is a very simple question. I have sat, I have listened. What do you think CLE should do so that from these conversations, when I sit in my office, I want to be able to say from the conference, this is what was suggested that CLE must do to change the structure of things. Thank you.
So, Prof. Muimali's question will be answered by every panelist, 1 minute, but I will start Dr. Thiankolu. And as you take the podium, Dr. Thiankolu, I don't know whether Ken Ogutu is in the room. When he arrived back with those good papers from the West, I asked him to come and teach in the university, although we don't pay very well. And I told him, if you don't, because we don't pay very well, criminals will teach our learners and will not be at liberty to complain. Proceed.
The first question was, what have I done as an individual to address, especially internally? One of the things I've done is, of course, I've raised these issues at the faculty board, at the board of examiners, and the other official fora of the university. Unfortunately, Professor Amora, my concerns have always fallen on deaf ears or been met with a refrain that says the law school is only an appendage in a bigger body called the university, and that these structural issues can only be fixed from central administration. Unfortunately, I have no seat in the Senate. I have no seat in the University Council. So the places, in short, the places where I have had a seat and a voice, including this forum, trust me, I have witnesses in the room who know I'm very vocal about these issues. I have, at the personal level, adopted a culture of perpetually improving myself, even as I point fingers at others. And of course, I mentor many students, usually from the University of Nairobi. Recently, I have one in the room from Catholic University. I see myself getting another one if Ongoya pushes from Kabarak. But the long and short is, I'm not the type that just pontificates and trying to do nothing about. Are we not forgetting where we've come from? It is easy to forget where we've come from. It is easy after practicing for 18 years and improving over 18 years to start now, looking at people who have not gone through that type of journey with a jaundiced eye. The truth is, we should remember where we've come from, but we should also remember where the world is and where the world is headed. The truth of the matter, I love speaking the truth, is that we are doing so badly. Whether we talk local studies, whether we talk regional studies, whether we talk global studies, that we should be mourning. And more importantly, asking ourselves, when the Holocaust happened, Ongoya, the Jews asked themselves, they said, never again. I hope CLE will after this workshop, reflect upon some of these structural issues and say, never again. What has happened. We can't undo it. But never again. Never again. Of course, we have wanting lecturers. We cannot have good products if the people on the manufacturing line are themselves incompetent. So we have to address the question of what is the competence and what is the capacity of our lecturers. Speaking for myself, these are purely personal views. A good law school should have a well-balanced blend of both practitioners and career scholars. Unfortunately, in the typical Kenyan law school, it is run by the career scholars, and they have lots of contempt towards people, especially without a PhD. And the time has come for us to accept that one doesn't have to have a PhD, to be a professor so-and-so, to be an effective law tutor. And if we agree on that principle, then having a PhD should not be the alpha and omega of promotions and your rank and the weight accorded to your views at the university faculty board, at the university senate, and indeed the other places. When I'm extreme, Ongoya, I usually say, you know, if I had to choose between my son or daughter being taught law in a law school full of only career academics, or in a law school that has people who even have an LLB, forget even the LLM, but they are people of the stature of Feroz Nauroji. They are people of the stature of Elisha Ongoya. I would prefer they are taught by people who actually practice that craft, and they have practiced it at all levels. Perhaps I should mention the reason Germany is such a great country is that the education system is more about competencies than the number of papers you have accumulated. In China now, I saw this week they have introduced this system Ongoya, where you can get a PhD not because you have written a thesis and researched and published, but because you invented a microphone like this that has revolutionized human life in some way. So I think the time for lecturers to be humble, especially the professors and the doctors so-and-so, Muimali, I hope that's one of the issues you negotiate with Q. And to your question, one of the things you must do is to stop Q from overshadowing you. Because what the universities did, for instance, when you and Q were fighting, especially over these LLMs I was mentioning about, the Commission of University Education, of course, supported by the university chancellors and the lecturers who know they are launching that product to raise money. They don't give a damn about the quality. They said, this is purely academic. The CLE can regulate the LLB and the ATP and these other things for professional practice, PhDs and whatever. We now have people who write PhDs on Goya that are full of spelling errors. And I know people are thinking I'm over-glorifying. I'm a male for heaven's sake, and English is not our forte. But surely, I was asking my student, the student whose email I was reading, and you forgive me for this, Ongoya. This student came to me for a meeting, and I asked her, looking at you, you have taken a lot of effort to wear a dress that properly fits you and accentuates your body, your front, back offices, and other offices. Looking at you, you have worn perfect shoes that fit you so well. You have even moisturized your lips. You have shaved your eyebrows to ensure they accentuate your aesthetic appeal. And I asked, how is it that when it came to running spell checks on your thesis, that's why you drew the line? When it came to ensuring there is a known referencing style used in your thesis, you suddenly drew the line. You weren't doing that. But you are very happy to apply RMEs or whatever you have applied, so that you have this sparkling type and glittering type of look. You have your very nicely polished nails. For the boys, your car is so well polished, it's neat, it's well maintained. But writing your essay seriously is where you draw the tuko na upuzi mwingi sana hii nchi. What is the role of lawyers in practice and academia, Ana Konuche? The bar must assist and collaborate with the universities, with KSL, with CLE. We are all stakeholders, and lawyers must do their part. They must equally subscribe to high standards of lawyering. I cannot be here doing wishy-washy, broad brush type of lawyering. Then I'm accusing the universities and KSL and CLE of doing a bad job. So basically for me, all these issues are systemic, and in that system, there are very many cogs. The lawyers have their place, the professors have their place, the Attorney General has their place, the judiciary has their place, and I think even the program for this workshop confirms that there is their place. Lastly, one thing you must do, sir, will there be a follow-up of action points from this workshop, or will it be another random thing we held? The reason I asked this, Jack Mwimali, in 2005, 2004, a decision was made. Everyone must go to the Kenya School of Law because the standards were falling, and that's how we resolved. Up to date, 25 years down the line, a quarter century down the line, no one has done any monitoring, any evaluation to see whether the objectives we sought to achieve through those so-called reforms of 2005 are working. And now, a quarter century down the line, we're actually in a worse place than we were at that time. And the question is, were all the sacrifices worth it? So to me, if there is one thing CLE must do, it is proper follow-up from all the contributions made this week in this workshop. You must distill what are the action points, and you must ask yourself, what is the vision of CLE on legal education and training in Kenya 100 years from today, 50 years from today, 200 years from today? Unless we do that, because the African never evolved, because of our being in the tropics where there are stable patterns of rain, dryness, for strange reasons we never learned to plan for the long term. If you check all the other cultures outside the continent, they already have a vision where they will be 300 years from today. And lastly, you must ask yourself, are we producing lawyers for the small kraal called Kenya, called Milimani Law Courts, Mombasa Law Courts, and whatever? Or are we actually, because for me, Ongoya, I actually believe we have an acute shortage, not of lawyers, but of good lawyers. And by good lawyers, I mean lawyers who can thrive at all the spaces I mentioned globally and locally. Thank you.
Thank you. I'll go to Mr. Abubakar. Why are lawyers like pigs eating their own children? And respond to Professor Mwimali. In all these things we are saying, what A, B, C can CLE do, so that when we come here 5 years from now, we are telling them we agreed you must do A. What is it that you have done? Proceed.
Thank you, Mr. Elisha. I remember one time when I did an interview when I was a young lawyer, and the interviewer asked me a question. What innovations will you bring if we hire you? This is a law firm, and you'll all agree with me that we're in a conservative profession. So that was a really hard question, so I just tried to meander it. And at the end of the day, at least I got the job. But a question that was posed by Professor Mwimali, the question is, what innovations can we bring as CLE? because we cannot do the same things that we were doing 10 years back. So the issue is constant innovations. And one proposal I have I can pick from the structural analysis that was done by Dr. Muthomi, is a conversation by the deans or the vice chancellors across the region in terms of regional integration and harmonization of legal education. Because if the deans are not having a conversation, then it will be Kenya advancing or Uganda advancing and leaving South Sudan behind, Somalia behind, because they're all part of the EAC. So all the deans across the region or the vice chancellors need to have a conversation on regional integration and harmonization of legal education. So this is a noble idea, having this inaugural conference, but I'm proposing that for the next, or through other forums or fora, there is need to have a conversation on all the legal or universities offering legal education across the region. There's also need to equip the lawyers in terms of not only the core subjects, but equipping the lawyers or the students now in universities, making them competitive in the international global market, so that we don't go for British lawyers in representing matters before the regional bodies or international bodies. So we need to advance in matters, the emerging areas internationally. The other, I agree with Dr. Muthomi, is in terms of bar associations. Bar associations play a critical role in this particular issue. And CLE must find a way of working with bar associations. One, in terms of CPDs. Through CPDs, we'll see how to increase sensitization in matters of regional integration and all other subjects. And also in terms of through CPDs, seeing how we can sensitize other areas of laws, because you cannot argue on cross-border practice and, for example, you have no idea on what is happening in, or you have no idea in terms of constitutional law in Tanganyika, constitutional law in Uganda. So if at least we can have a chance to study the laws across the region, then you can argue on cross-border practice and improve on competence. Also have a discussion in emerging areas of laws, like digital rights, data protection, and the ethical aspects of it. Because as we speak right now, it's an issue where you have lawyers relying on ChatGPT. Right now in Zambia, there's a senior counsel who's undergoing pupillage afresh by virtue of the senior counsel using ChatGPT and citing authorities that were non-existent. So the court ordered that for 1 year, be under this young lawyer and understand the ICT aspect. So what are universities and law schools doing in terms of the ethical aspect of using these digital platforms? Another aspect is the safeguards. If everyone is studying virtually and doing examinations virtually, what safeguards are we coming up with as universities and the Council of Legal Education? I think there is dire need, and this can only be done through CLE and the Bar Association. Coming up with safeguards that will guide not only Kenya, but also across the region. I think I'll end there. Thank you.
Thank you. Thank you so much. Let me go to Dr. Pamela. Just respond to the CEO of the CLE. What take home? What can he go and tell his staff and his board? Let us do ABC.
Thank you very much. I'll be quick, but first to clarify about that 7,000 number that you said we thought was too high. 7,000 are those who are practicing in Kampala, those who have been there. Kampala is quite small in terms of, you know, the market or the pie that they've got to share among the advocates. So our concern is that this year we had 3,000 students at the Law Development Center, and if you're going to churn out 3,000 every year, where are they going to go if they're all only looking at Kampala? They will have to, of necessity, you know, fan out into the upcountry towns. Now, in terms of what the CLE CEO asked, I'm a John Maxwell fan. He says everything rises and falls on leadership. I'll let you know that in Uganda, the Attorney General leads all the international arbitration, the current Attorney General, was spending way too much money on external counsel. So when he came into office about 4 years ago, he decided he was going to study what does it take to represent ourselves at that level. So he started off by having maybe just 2 of the external and the larger team is, but he leads the arbitration himself. It has saved us a lot of money, but this has come from his own personal initiative. As an AGU saying, it's time we saved ourselves these unbearable costs by hiring these external lawyers. 2, in terms of the LDC itself, I'm just giving the example of, leadership. As I said to you last year, we decided to clear all the backlog by taking on 2 intakes. Now, in terms of the new draft bill, the draft National Legal Examination Center bill, we had this fight with our National Council for Education. I'm coming to what you're saying that we should strengthen the Council of Legal Education here versus Q. And I think you heard the Executive Secretary of Q saying yesterday that he is supportive of some collaboration happening with the body here. We have that mandate fight in Uganda. When we were discussing last week at the stakeholders conference, the Executive Director of Education said, it appears you lawyers want to take away our mandate to accredit the law programs. The Attorney General was chairing the meeting and he said, yes, that's the plan. We are going to take away that mandate and give it to the Law Council. The Law Council is our equivalent of your Council on Legal Education and Training, because we believe they're the right people. You go to the expert to accredit a particular program. Similarly, in India, we did discover that the Bar Council of India is extremely strong. And as I said on Monday, law and medicine have been excluded from the proposed National Higher Education Authority of India. Law and medicine are not going to be part of it. The mandate will remain with the 2 professional bodies, the Bar Council of India and the council that governs their medical training. So I conclude by saying we need to identify champions. Who are going to be the champions to help us implement these reforms? In Uganda, our champion is the Attorney General. Really should be on speed dial with the Attorney General. The Secretary, I'm on speed dial with my Attorney General. I let him know what is going on exactly, where we want to go, because we are the technical people to advise them. So speed dial with the Attorney General, speed dial with the Chief Justice, the Committee on Legal and Parliamentary Affairs, because the ones who handle all the bills are taken the second reading before the second reading to that committee, Speaker of Parliament, and certainly the Uganda Law Society. In this case, it would be the Kenya Law Society. These are your same people who understand and appreciate the problem, so they have to be in the room when you're having the conversations, and they have to be the champions to lead that discussion in those spaces where you may not be, and they can speak for you. At the end of the day, who is the current CEO of Council of Legal Education? Who is the current AG? So yourselves there, today we are the ones here in this room today as we are seated, 4th December. So what are we going to say in terms of our statement, and how are we going to commit individually to move the discussion forward? Professor Jacquet, before you came, I had said that IUCA had started the conversation on the cross-border practice legal bill. The ones who actually sponsored it when we first met in 2011 and disagreed. IUCA also used to hold specialized committees of the different disciplines where we would meet as deans, what you are saying, the deans meeting regionally, sponsored by IUCA. We last met in 2005, to my recollection. So these are things we could revive with IUCA. 1, they have funding. 2, they are more independent in terms of the ESC, in that the donors give their money directly to IUCA, while the other bodies have to take from the basket and share it out. So IUCA should have been at this meeting. I didn't see them, but they should have been at this meeting, because they are potential champions. The East African Common Higher Education area is being driven by IUCA. So let us plug ourselves into that conversation right now on harmonization, using their expertise, their funding, and their ability to speak at the regional level. But in terms of ourselves here today, like I said, Kenya and Uganda seem to be moving in tandem. Maybe we start there, and then our friends will join us along the way, because somebody has got to start. Thank you very much.
Thank you, Dr. Pamela. Finally, Ms. Again, proceed and give us your final thoughts to Dr. Professor Mwimali. What can he take to his board and say we can do A, B, and C?
Prof, we've spent 3 days talking about all sorts of things. We've diagnosed the problem, and I think many solutions have also been put forward. And at the end of the day, as Pamela has provoked you, the responsibility rests with the CLE to provide the direction for what the future of legal education looks like in this country. And I think I mentioned to you earlier on that I noted that this conference was being called the Inaugural Conference on Legal Education, and reference was only being made to the Lord Denning report. Yet, from the Kenyan perspective, there have been many efforts towards trying to address the very questions that are being addressed today. There have been numerous stakeholder conferences held around this point. And it seems to me that our solutions stand on the need to do the following. One is to have, I think, clarity on what legal education means in terms of having a clear policy. I think this question was posed yesterday. What is the philosophical underpinning of legal education? And I think tied to that is the issue of, do we have a clear legal education policy? And I know that this is a discussion that's been happening for quite a while in various spaces, including through the Attorney General's office. And it seems to me that we need to have complete clarity on what undergraduate law training entails. I think a lot has been said about what it should or should not entail. But I think we need to have clarity on that. And from where I sit, you cannot take away the responsibility for doctrinal foundations, for building research, analytical, and critical thinking skills at the undergraduate level. We have to have clarity about the role of the advocates training program, which should focus on practical skills. And you know that through the auspices of the working committee that I recently chaired at the request of the Attorney General, these issues were discussed through a multi-agency conversation between yourselves, the Kenya School of Law, the Law Society of Kenya. And I think we should note that all these these institutions responsible for legal education are represented on your council in recognition of the fact that this is an ongoing conversation. Ideas and solutions must come from these key actors in this process. But I think equally important is the need to focus on who then trains the lawyers who are already in the workforce. If, by bad luck, they get through law school in the kind of scenario that Dr. Thiankulu described so vividly, they make it to the advocates training program and still come out with challenges with the gaps that we are talking about, then the issue is who focuses on training those lawyers who are in this space. And again, CLE has to be part of this conversation, because then you guide what the entire process of training looks like. And as far as I'm concerned, training beyond university and the ATP is the space where the remedial training will be done. And so this is a conversation that must be had. Alicia, because I have the microphone, I wanted to say something about regional collaboration, which was the thrust of this session until Mudhomi regaled us. with very interesting insights. Regional collaboration is a way of strengthening knowledge and addressing skills gap. And I'd like to speak about this from the perspective of the challenges or what's being done to try and build capacity in law reform and development. As you know, I chair the Law Reform Commission. And we have noted that through the collaboration of agencies in that space, law reform agencies, we are able to share knowledge, skills, etc. This is post-qualification, but like we said, specialist training must happen at that level because not everything can be offered at the other levels. And one of the things that we've been having discussions about is supporting institutions that can offer the kind of training we had. Remember, I pointed out that there's opportunity for training by universities, by the Kenya School of Law, by the LDC and others. And recently, through efforts that we have been going through, we've now launched, the University of Namibia has now launched an LLM in legal drafting because there's been, really a lack of this kind of training provided in the region, other than perhaps what is offered in University of Ghana. So collaboration where countries agree that they will support one particular training institute to offer the training that's needed is a good way of making sure that we do get the specialist training. But I end by saying that CLE, whose strategic goal is to transform legal education and training in Kenya, has the responsibility of taking all these recommendations that are being made and turn it into actionable, strategies and activities. Thank you.
Thank you so much. Let's clap for our panelists kindly. As that happens, I wanted to see the gift packs for my panelists, and as the gift packs are coming here, I want to see a member of the CLE board, Mr. Sam Alosa, come forward to hand over the packs to my panelists. Mr. Alosa, if, I can't see anyone in the room because of a sight problem, but Mr. Alosa, if you are there, you come over. Thank you. Oh. Yes. So we'll start with Ms. Agimba. Take her gift pack. Ms. Agimba, step forward. Take your pack from Mr. Sam Alosa. No, there's one for you. You will give it. I hope my cameramen that I sent here 2 weeks ago are on standby. Thank you. Thank you so much. Next, I have Dr. Mudomi Thiankolu.
You were saying because I spoke badly, I should not get
No, I have an announcement for you in a short while. I have some announcement for you and some assurance for... Thank you. Thank you so much. Next, I have Mr. Abubakar. Finally, I have Dr. Pamela. And Ms. Ann Konuche, I know we have done very badly with time, but because the person who messed up the time is Dr. Mudomi Thiankolu, he's the next moderator. He has an obligation to recover the lost time. So don't worry at all. Thank you so much, good people. I'll hand over the microphone back to Ms. Konuche to tell us the next course.
Thank you so much, Mwalimu, and thank you for the panel for the very good and bad words that have been spoken. We are going to proceed for tea, where we've been having tea downstairs, and I urge us to take it in the next 20 minutes so that we come back for the next session. Now, we have also combined the next two sessions. So the presenters, for those who are supposed to present after tea break, And those who are supposed to present after lunch, please note that you will present consecutively after we have our tea. And we also intend on closing the conference before lunch. So we urge your patience so that when we come back, we take the shorter times in the presentations, then we proceed to the closing ceremony. Also, the hotel has requested that they need some tables, and so there will be reorganization. I think one of the 2 tables at the back will be removed. So I urge that maybe you could move to the front, catch a seat here at the front, and place your belongings here so that the tables can be moved. Other than that, I welcome you for lunch. Thank you very much. Oh, sorry. Hey, sorry, for tea. For tea, definitely tea. So I want to take this opportunity to welcome you back to the session. The second and the last, more or less last session of the day. As we prepare to receive the panels, I'd request, is this thing okay? I'd request the representative of National Bank. You need to fix this. Okay, yeah. The representative of National Bank of Kenya, who is one of our sponsors, Ms. Purity Kashoki, to come and give us a word in 2 minutes.
Hi, good afternoon, ladies and gentlemen. Good afternoon, ladies and gentlemen. My name is Purity Gashoki. I'm here representing National Bank. It's an honor to stand before you today, not only as a banker from the National Bank, but as someone who deeply respects the role that the legal professionals play. I hope we are together. There is a bit of movement. Maybe in a minute we can settle down. So we've just come in. It's quite intimidating standing in front of lawyers, but all in all, we are all professionals in our ways. And for our theme today, it could not be more timely. Lawyers have always been the interpreters of our societal values and guiding us through change, and for that we always appreciate you. At National Bank, we are proud to be financial partners for Council of Legal Education and working with them through this journey, and we would also want to be part of the journey with you. So as a bank, we may not know all the sections of the penal code, or personally as a banker. However, we do understand partnership. We understand the power of building the future together. And speaking about the future, and it goes together with the theme that you're talking about today, and forging the future for the legal profession. So one of the biggest dreams many Kenyans share, and all of us here in the room, is owning a home. And home ownership is very emotive to all of us. And that is the journey that us as National Bank would want to work with you in terms of providing home ownership solutions. So a home is somewhere that you in the legal profession, you can, go back, your day slows down and you just sit down and relax. And that is what we do, is give you home ownership solutions through our mortgage solutions. And that is a product we'd want you to engage in with our team right outside. And we have spent years helping thousands of families turn their quiet dreams into front door with keys. Our mortgage solutions are built around flexibility, affordability, and understanding of you as a customer. So we request that you talk to us, we walk you through that journey. It may be owning your own home, or even investing for the future when you're not able to stand at the bar and defend your clients, and we'll be very happy to work with you. So once again, I want to appreciate Council of Legal Education for having us here, and also appreciate the legal professionals who have turned up here, and we continue to give you our commitment to support you and to be your preferred financial partner. Thank you and have a blessed day.
Thank you so much, National Bank. I want to call upon Dr. Mudomi Thiankolu to start coming here. so that he can marshal his panel. As he does that, let me acknowledge Mr. George Nyakundi, who is here representing the Solicitor General, and also to acknowledge the latest senior council members who've just been nominated. Dr. Muthomi Thiankulu is one of them. Ambassador Dr. Koki Muli, who was here yesterday, Ms. Christine Gagimba, who was here this morning, and Mr. Elisha Ongoya. From myself and I think CLE, congratulations. We wait your gazettement. So we can give them a round of applause. All right, so let me hand over to Dr. Muthomi. You have, I guess, about maybe 45 minutes before we hand over to the next moderator. Karibu sana.
Thank you very much, Anna. Our presenters for the next, or panelists for the next session, Mr. Joel Monda, please come forward. Joel Monda will be presenting on behalf of Juliana Gujiri, no, Njiriri, sorry, Joel Monda. Then we have Dr. Harrison Otieno Mbori and Professor Otinga Mare, if they can quickly step forward. So Joel Monda is a lawyer and is still doing his training. He completed his coursework for the LLB. He's an emerging voice on legal education in Kenya. Can we give him a round of applause? Dr. Harrison Mbori is a postdoctoral research fellow at the Luxembourg Center for European Law. If I'm mispronouncing Luxembourg, Dr. is because I come from Meru, and that's exactly what we do. He's also an adjunct lecturer at Kabrak Law School and an advocate of the High Court of Kenya. Can we give him a round of applause? Professor Mare Otinga, I don't know, is he in the room? Okay, once Professor comes, you please someone usher him to the front. He is the founder and CEO of Mandaraka University Corporation, and they will speak to us, as I said, on the theme of regional harmonization and standards in legal education. Dr. let's begin with you. I'll give you 10 minutes. Then I'll give Joel Monda 10 minutes. If Professor comes, we'll give him 10 minutes. Thank you. You may use the mic next to you, or you can use the podium.
Thank you so much, Dr. Thiankolu, who was my teacher at undergraduate level, so very happy to be with you on this panel, and to the many friends and colleagues who are here, and of course to CLE for organizing this wonderful conference. I do have some slide presentations because some slides for this presentation. This is a paper presentation, so I'd like to possibly ask that they be projected so that I can begin. The topic I'm dealing with is sovereign trust deficit and legal harmonization in the East African community. I have 10 minutes, so I'll try to go really fast and see whether I can deliver the points that I make in this paper and I intend to deliver to you. So the outline of the paper is as follows. I just have a general introduction. I'll tell you some legal imperatives, a bit of a conceptual framework, and tell you about regime complexity and then what is the sovereign trust deficit, and then I'll conclude with some concluding thoughts. The first thing I normally like to do is just tell you what is the main argument of my paper, my claim. My claim is that even if we do legal harmonization in the EAC, like in many other regional integration frameworks, we are still facing and will continue to face the weighty challenge of sovereign regulatory trust deficit. But I know you might ask yourself, what is this thing I'm calling sovereign trust deficit? The concept is possibly a simple one. This is the lack of mutual confidence among states within an integration effort of each other's regulatory systems, standards, and conformity assessments. So it's a lack of trust that regulators have upon what the other party has. I think in our context, it is really accentuated by in cases of harmonization, because we now require mutual recognition and harmonization at the same time. And I'll tell you that those two things are different and difficult to do. I've had in this conference some talk about mutual recognition, but I've had a lot about harmonization, and I'm a bit skeptical about harmonization, and I'll tell you why I'm skeptical about harmonization. The reason why I'm skeptical, okay, so let me give you the legal imperative. So we have a common market protocol in the East African community. I've had people say that it is only an intergovernmental organization. No, it is much more than that. Maybe not as supranational as we want it to be, but it is close to one. And the Common Market Protocol in Article 11.1b requires some harmonization. It requires the harmonization of curricula, examination, standards, certification, accreditation of educational and training institutions. That is what is required. We need to harmonize that. That's what the treaty is saying. Pursuant to this, at the moment, what we have is some regulations. They're still in draft. There have been 2 regulations, 2011 and 2022. And the reason why this regulation is still in draft is also because of a sovereign trust deficit. I think Burundi and DRC, at the time that they were concluded, weren't able to sign at that particular time. And when I tried to find out why, I noticed that it might also be related to questions of language and trust on this framework. So the regulations are very robust. But Article 11 requires both, not just harmonization, requires mutual recognition. So my main point in this paper is to tell you there's a big conceptual difference between mutual recognition and harmonization. And that's the next point that I want to make. In order to understand this difference, in my slide, I tell you how there are 5 factors you need to think about in order to distinguish mutual recognition, harmonization, and I will talk about national treatment. So mutual recognition is this idea that you do not need to make everyone have the same or similar regulations, but you will have some equivalence and say, I recognize the other's regulations as similar to mine, and therefore I will allow them in. In our framework, we now have academic mutual recognition and professional mutual recognition. And at least for this conference, what is more important is academic mutual recognition. But we haven't been talking about academic mutual recognition. What we have been talking about is harmonization of academic qualifications. And now I'm going to tell you why these two things cannot be done together at the same time, why harmonization is difficult, and why maybe we should do mutual recognition. The first reason is because for mutual recognition, the home country regulatory authorities maintain control. So this is good for CLE. They don't have to, or any other regulators, it's just not true for CLE. They don't have to cede much of their regulatory authority. The costs are disadvantageous because the people who are going to enjoy the services, the legal services in this case, like students or the general public, will have huge costs because we're going to allow other people from other countries to come and deliver their services. There's going to be some horizontal transfer of sovereignty, so this is definitely going to happen for mutual recognition, and there's going to have some primate levels of trade. But in order for mutual recognition to happen, there have to be some market freedoms. And we still don't have enough market freedoms in the region. I was going to Uganda recently, 2 weeks ago, and I don't know, it sounded like a miracle to me. Someone at the airport asked me for my visa, and I was absolutely shocked. I said, visa? The last time we went to Uganda, we've never needed a visa for Uganda for a long time. They said, oh no, they're changing some regulations, we don't know. So this is Uganda, so you can imagine Tanzania is sometimes a little bit worse because you ask, what are you going to do? Yeah, where's your document? You are appointed for East Africa Court of Justice. Where are those documents? I need to see them. So we are not even moving freely. So you can imagine if we do not have these market freedoms, how are we going to be able to mutually recognize? If you think mutual recognition is hard, harmonization for me is even harder because harmonization requires a unified supranational institution, and the EAC is not yet there. Harmonization has high negotiation costs for states. In my paper, I'm arguing that there is a huge regulatory complexity, not just in Kenya, between the Council of University Education, CLE, the judiciary, and even the Law Society of Kenya is involved. I've tried to ask some colleagues who really regulates the legal profession, and I've been told in Kenya it depends with where you stand. Are you still a student? Maybe you want to join the profession, maybe CLE. Have you been admitted? Maybe LSK, but also the judiciary, because you apply to the judiciary now to get your practicing certificate. So if we were to sign a mutual recognition agreement, who's going to sign it? Okay, let's talk about harmonization. If we are going to harmonize, who's going to be the competent authority to negotiate the harmonization? Is it the Council of Legal Education? Is it the CLE? And how are they going to divide their competencies, already seeing that there is regulatory competition at the domestic level? I will have spoken a bit about national treatment, but there's no time. That's the other framework. Let me tell you how costly harmonization is. What we're trying to do is to do what the tech world has tried to do with the USB-C. If you've bought any product now, there's a lot of USB-C. Previously, we had this problem with all these types of USB. Some people had this 10 of them in one. The USB-C is slowly becoming the king. This is what we want to do with harmonization of legal education, and we don't even have a philosophy of what is the type of lawyer that needs to be trained. Yesterday, there were 4 different philosophies on the table about the kind of lawyers we want to train. One is a very market-based neoliberal philosophy. We need to train entrepreneurs. Lawyers are business people. They need to make money. The other one is that lawyers are supposed to be social engineers for rule of law. And this can be different for different universities. The other one was that we need to create ethical lawyers who think about the human person as a whole. That was the other theory that was presented. And we need to harmonize. We need to harmonize so that we have a single theory for Kenya before we can go to negotiate with Tanzania, which also has to harmonize what type of lawyer they want, and Uganda. And I've not started talking about DRC. I've not started talking about Somalia, which has joined. I've not even spoken about Burundi. And when you're negotiating currently, DRC and Burundi want translations in French because they speak French mainly. The cost of negotiation is crazy. And we're talking about harmonization. The point I'm making to CLE is maybe you need to avoid it if you do not have the money, the resources, the time, and the amount of resources that will take us from all these types of USB to USB-C. And it has taken the tech industry many years, and including EU legislation for companies like Apple, which makes this Mac products, to now move to USB-C. It took legislation in Europe, and it's because they didn't want to lose their market in Europe, that's when they went to USB-C. What will it take for us to harmonize our legal education? I think it will take quite a bit. And that is the reason why I am skeptical about the idea of harmonization. I am very skeptical. Okay, and this is my regime complexity slide. This is just for Kenya. There is overlapping mandates. Okay. So this I won't go through a lot. Let me tell you the next slide because it's the one that is before my final slide. This is the regime complexity for the region and not the entire region, just the 3 primary EAC member states. If you look at what is happening, this is just, if I were to draw a diagram, it will be even more complicated. Who's doing what? Why are they doing it? Why do we have a 2-tier system? Why university and then professional? It's crazy. Okay, again, because it's a short presentation, not everything. Read my paper. Maybe it's supposed to be that. Finally. 3 points to finish. The manifestations of the deficit. These are the 3 points. These are the manifestations. 1, we have perceived quality disparities. I'm not very sure whether we trust that the lawyers that are coming out of the other countries are good enough. I am currently doing a case in the EAC where we have a Ugandan lawyer trained in Uganda, then in Rwanda LDC, they got a job at the ODPP in Uganda, and they were told, that country is civil law, you need to go for pupillage here so that we remove the rough edges. The last time PLO told us that the reason why we're going to KSL is you have rough edges, we need to make them sharper. And we're still talking about some of these things. And I've had these cases, Ugandan lawyers in Kenya, it keeps on, repeating and going on. Systemic divergence, I think Dr. Thekol spoke about this. The one talk about the most is this idea that we have friction between common law countries, Kenya, Uganda, and Tanzania, and civil law countries. And we think we're not very sure, what do those people do? What is their system? How does it work? And I've not even started talking about the language disparities. Just imagine how difficult it is going to be to harmonize that. And then economic protectionism. The lawyers I've spoken to in this country have told me, these guys are coming to take our jobs, they're going to compete with us. We already are complaining about 920 lawyers internally, and now we are supposed to open up for lawyers from the other regions. I don't know whether the practitioners are ready, because we're not just opening within the EAC, we have to open for Africa because of the FCFTA. Mwalimu, let me stop there. Time is too much.
Thank you very much, Dr. A round of applause. For those who are doubting that I'm a good teacher, you can see it was one of my products, so my political enemies can go easy. Let's have our next presenter.
The CEO, Council of Legal Education, and all protocols observed, good afternoon. It's a pleasure to stand before these great minds in the land. I also acknowledge that I was also a student of Dr. Muthomi Thiankolu, and I hope I was a good student too. I'm privileged to stand before you to present a paper, and because you have always been told it is not right to speak much than more than your elders, I'll try to be as brief as possible. This paper, I co-authored it with Honorable Juliana Nziriri Weke, who would have liked to be with us here, but she has been called for an official duty, so I tender her apologies. Now, we co-authored a paper entitled Curricula Without Borders, a strategic framework for harmonizing legal education standards across Africa's trade blocs. Now, before I proceed, in this context, when I'll be speaking about harmonization, notwithstanding what Daktari has presented to us, I'll be speaking about harmonization from a point of not necessarily identical standards across Africa trade blocs in legal education, but from a point of comparable identity, right? So the standards at the end of the day don't have to be exactly identical, but we can have a middle ground of structured equivalence. And the structured equivalence theory forms the underpinning theory, one of the underpinning theories of this paper. Now, when the agreement on the free agreement on African free continental free trade area came into force, it had a noble aspiration of facilitating Mode 4 movement of professionals across jurisdictions in the African continent. It is a very promising agreement, which united figures and projections indicate that if fully implemented, it can unlock a 3.4 trillion worth of market in Africa. That is the economic value that this agreement can unlock. And Article 3A and 3B, and also Article 4B of the agreement, in combination with the Protocol on Trade in Services, they all have this noble aspiration of unlocking this market. But speaking of now the legal services market, which comes up as a main point of the debate in this forum, when you look at it, one of the most pressing hindrances that has hindered movement of professionals across jurisdictions in this trade bloc is a lack of harmonized standards, right? That is a very pressing hindrance in regards to having a conundrum in regards to movement of legal professions. It has been so difficult for legal professions to move across borders, as it has been reiterated before. The same has been demonstrated. Now, the quality of any legal system is directly proportional to the quality of its legal education standards. Directly proportional. Because the legal training standards will inform eventually how the law is formed, how the law is drafted, how the law is interpreted, and how the law is applied. It all goes back to the standards, to the formative standards. So we can't wish it away. We have to talk about what are these standards? What values do the standards that are existing carry? And what can we do in order to bring the standards up to par? Because at the end of the day, we are aiming to facilitate cross-border legal practice. We must have the basic fundamentals of how training is conducted. So we have created this very good agreement, very promising agreement that is in sync with the Agenda 2063, which aims to project Africa at a level where it will be peaceful, integrated, and prosperous, right? But before we walk to that agenda, we have to deal with the basics at the training level. So in this paper, we analyze those basics and put forth proposals that can aid in walking towards that journey of a prosperous Africa of 2063. Because we have this very promising agreement, and without the requisite professional training standards in the legal aspect of it, then it is like having a very advanced machine, but without the corresponding adequately trained mechanics to handle this machine. So we have to go back to the basics and analyze how we can harmonize our standards across jurisdictions so as to inform the quality of lawyers that we want to practice across border. The world is moving fast, and we are more and more moving towards globalization. We can't deny it. That's why even in some quarters you hear of theories like the one world order theory. We can't resist globalization. The world will become more and more global as time goes by. So we better take this moment and really work on proper standards that will elevate our legal practitioners to that global level so that we are not left behind. Because whoever resists change is eventually consumed by it. So we cannot deny this change. We have to adjust accordingly. So in our paper, we have proposed a 3-part model to enable us scale up to the required standards. All right? We have pillar 1, which is the content level pillar. And this pillar provides for the basic units that should be taught across the jurisdictions of the member states of the AFCFTA agreement, right? And in this content layer, we can have an irreducible minimum of subjects which must be undertaken by students across these jurisdictions, such that when it comes to dealing with matters that are cross-border, the practitioners will have been well prepared from their institutions. And these subjects include subjects pertaining to digital justice, cross-border competition law. We also have an aspect of AFCFTA law, which was spoken about by the panel yesterday. Stroke regional integration. At this point, regional integration should not be an optional unit in the university. It should be a very compulsory unit, forming one of the core course requirements to that regard. And also, we can also have other units pertaining to human rights and emerging energy transitions, forming the core minimum at the undergraduate level across jurisdiction. So all the units taught at the LLB level may not necessarily all of them be equivalent, but we have the few basic that must be taught across board. That is through harmonized standards as will be put forth by the requisite facilitators who are supposed to work on harmonizing these standards. So in conclusion, we have recommendations for regulators and for the AF-CFTA Secretariat and for the development partners. All of them should work in harmony to harmonize these standards by building joint curriculum review panels and also embedding technological legal training as a key pillar in the training process. At the end of the day, to conclude, the reason why we are having most of these agreements and treaties not being fully implemented to the core, for example, Article 126 of the East African Treaty, the East African Community Treaty, espouses harmonization of legal training standards, but we have not achieved that up to now. It all boils down to political goodwill. So all the stakeholders must collaborate with the players in the political sector, to do lobbying, intensive lobbying, in pushing towards harmonization of these standards. I conclude by saying, in order for Africa to harmonize, we must first harmonize our minds. We start with our minds first before moving to the other processes. Thank you very much.
Thank you very much. A round of applause to our presenter. I'm told because of the constraints of time, we'll combine the plenary session for this panel with the next panel. So if we could have Dr. Felix come with the next panel. I hope Anna Konucha have kept the time. I was listening to this. Felix, you're the one holding us. I was wondering why our doctors drive in New York, in Canada, in wherever, but our lawyers cannot drive in Uganda and Zambia and wherever. Why is it that our Kenyan nurses drive everywhere across the world, including the developed world, but they don't drive here? Thank you. Anna, over to you.
Thank you so much, Daktari. I think they deserve a round of applause. Thank you so much. You can step down from the podium. As Dr. Felix comes over with his panelists, I want to invite the representative of Jubilee, Irene Kadhuki, to give us a word in 2 minutes. They are also one of our sponsors. Irene?
Good afternoon. My name is Irene Nyawera Gaduke from Jubilee Life Insurance. We are grateful for this opportunity, and we are grateful for the Council of Legal Education for this partnership with Jubilee Life Insurance. We do not take it for granted, but we are forever humbled for this partnership. We also want to appreciate you for all attending and for even finding time to visit our booth. We want to basically talk to you on where you should feel free to visit our booth and we are also happy that the Council of Legal Education is already a client with Jubilee with their pension, and we can promise that your pension is fully well managed, and we are proud to say that you'll get the best rates in the end of the year. And my question is, why should you plan and have your retirement benefits with Jubilee Life Insurance? I will talk just 3 or 4 pointers to just basically encourage us on why, and especially as lawyers because we're in the legal field. And the first one, why plan, is because of the financial security, to minimize your taxes and to make sure that you fulfill your goals and your targets in the near future. And number two is to be able to invest wisely. In the current state of affairs in the country, we need to have money in the future. And in short, what we are here to tell you is that you're going to invest and your money will get good returns. And instead of just aging, you're going to age gracefully without fear of the future having to retire without a plan. And lastly, it's about estate planning and legal compliance. We all know that for you to have your pension, it's very important to have legal compliance with the Retirement Benefits Authority, and we are happy that we've continued complying to that and partnering with Jubilee Insurance. We want to welcome you after this to feel free to visit our booth so that we can get to tell you more products that we have on investment. We have also products that have very high return rates, and kindly feel free. Once again, thank you very much. We are really grateful. Baraka.
Thank you very much, Jubilee, for being valued partners. Daktari, the floor is yours.
Thank you so much, Director Anna. And at this particular point in time, my role is to moderate the next session. And this session deals with the implementation, I would call it the implementation of the points of action that are coming from this particular conference. We're talking about the future of legal education. And all those recommendations in terms of how they are to be executed, in terms of the training of the next generation set of lawyers in this region, have to find a place in terms of the curriculum, so that how the teaching is to be done will then be addressed within that framework. It then becomes my pleasure to welcome the presenters who are making proposals in terms of how the implementation, the teaching is supposed to be done to the next session. So at this point in time, please allow me to invite the panelists, starting with Ms. Jacqueline Mudhoni Mwangi. Please step forward. I believe I saw her here. Jackie Mwangi. Jacqueline Mudhoni Mwangi. She's not, she has stepped out or something. Mr. Jilo Guyo Jilo and Ms. Amara Vishram. As she makes her way to they make their way to the podium, please welcome them with a round of applause. I hope Jackie Mwangi will find her way here soon enough, because she was here until a short while ago. I remember seeing her. So when she comes in, she can be ushered to the podium. So Jilo and Vishram to this panel. Thank you. So maybe let me just welcome, do you both intend to present, or one of you will be presenting? Both present. Both of you? Yes. Okay. So, Jacqueline will be here in about 10 minutes time. So who of you would be starting us with the conversation? Okay, Vishram, please welcome.
First of all, we'd like to mention what an honor it is to be here speaking before such recognized professionals, and both of us would like to preface this by saying we are in our first year, so if there are any questions, please go easy on us. We have heard a lot of slander about the quality of English of law students, so we hope that we can at least defend our reputation. With that being said, we would like to present on a concept that we had on accrediting experience, which is dealing with the bridge of theory and practice in today's legal education system through integrating clinical work and research and other forms of experiential learning into law degree programs. However, there is a slight clarification. This is not the full depth of our paper. Our aim today is to open a conversation about the place of experiential learning in East African legal education, to outline the landscape, identify the gaps, and frame the issues that our written paper interrogates in more detail. Our presentation is on the board and it is titled Accrediting Experience, Bridging Theory and Practice in Legal Education in East Africa. We explore why experiential learning matters, why it remains undervalued, and how our accreditation-ready framework could strengthen both legal education and access to justice across the region.
To understand the problem, we begin with a simple observation. The East African legal education has modernized, but is very modernized, but slightly highly theoretical, where graduates are professionalized, but the focus is not highly on hands-on skills. The Kenyan competency-based curriculum is here with us, and the activities that are there in the current legal system, in the current legal educational system, are not hands-on enough, is more theoretical and less practical as the competency-based curriculum advocates for. There's the rapid development in AI, which is currently changing the structure of the legal education in Kenya, because we can deal with matters to do with the theory through the use of AI. However, you cannot change practical experience with the use of AI. And with that, we'd like to pass it to Amara.
Okay, so we're presenting our core argument here. Experiential learning should not be optional, informal, or treated as an extracurricular activity. It should be structured, recognized, and accredited. Using models like Strathmore's service-based learning and work-based learning, we argue that East African institutions can bridge this theory-practice gap and prepare students for a CBC-aligned and AI-driven future. And keep in mind, this is not just Strath arrogance talking. We are coming at this because it's a viable model that has shown that experiential learning can be implemented for every student across their degree program, and we believe that this can be scalable across universities in Kenya, regardless of resource constraints due to the flexibility of its nature.
The Council of Legal Education has defined experiential learning as knowledge gained through work experience, informal training, or life experience. This is practically seen through internships, legal clinics, mood simulations in the Kenya School of Law, community service, pro bono activities, and others. However, you cannot, we treat activities such as this, and we'd like to advocate for the alternative classroom measures put in place.
3 broad benefits have emerged from our research. The first of this is skill development. Experiential learning builds practical competencies, client interviewing, drafting, judgment, teamwork, that simply cannot be fully taught in lectures, no matter how good your lecturer is. Second, there's equity and access to justice. Clinics and community-based projects expose students to Kenya's justice gaps, aligning legal education with social justice and public interest. And this is something that both of us have felt personally. We are both members of the Strathmore Law Clinic, and we interact with communities that we would have never otherwise been able to should we have stuck to a purely theoretical idea of legal education. And this is why practical outreach is so important, because not only does it broaden your experience, it broadens your mindset. Which leads us to the third benefit, which is bridging the theory and practice gap. Experiential learning creates ethical, adaptable lawyers to be able to apply doctrines to real problems, especially important now that AI covers more routine tasks, because you can outsource theory, but you can never outsource experience.
In our East African community, we acknowledge that such measures have already been put in place to develop experiential learning. In the case of Strathmore, for example, with its structured work-based model or service-based learning that is already in place. The University of Nairobi and Kabarak University clinical aid initiatives and moot centers that are already there. Nigeria and South Africa, which go beyond the East African border, to develop experiential learning, to make it a mandatory or compulsory clinical program. So we're looking at it from the aspect of a common thread where we're pushing for learning by experience, the learning by experience philosophy, rather than just the classroom setup ideology.
And like we mentioned earlier, we use Strathmore as a case study because it offers a working model of structured experiential learning. It is viable, and yes, it is not without its flaws, but it is something that can be improved on and scaled. The main tenets of this are based on 3 elements that Strathmore practices, which is the service-based learning, where we have 225 hours of mandatory experience where you engage in supervised community-based work that blends social impact with legal education. Work-based learning in the form of internships, where we form partnerships and have structured placements in firms, courts, NGOs, and companies, each with set goals, assessments, supervision, and logbooks, and our accreditation approach. These placements are treated as academic components. They involve proposals, rubrics, evaluations, and reflective learnings to build to the ultimate outcome of high job placement, employer satisfaction, and improved preparedness for KSL and early practice, which we have already established through informal interviews with leading members within the legal community.
We believe that the service-based learning and the work-based learning experience works because there is clear supervision by lecturers, there is documentation of student progress, partnership with firms has exposed students to different work experiences and work ethics, partnership with different community organizations, and competency is mapped to the learning outcomes that a student should come out with by the time they finish their 4 years LLB program. The elements are precisely what an accreditation framework would highly require.
The CLE already recognizes experiential learning in theory and even awards experiential certificates for practitioners. But there is no requirement that undergraduate law programs embed structured experiential components or assign academic credit to clinics, internships, or moots. Our argument is modest. The CLE does not have to overhaul the entire system. It can update accreditation guidelines to formally recognize structured experiential learning. This would provide consistency, quality assurance, and incentives for universities to invest in community-based legal training, or placing the others back in the law schools.
The competency-based curriculum emphasizes on skills, values, and active learning in the classroom setup. So the experiential learning setup is similar to what happens in the CBC program, where there is digital and AI literacy that is provided through the experiential learning, ethical problem solving, communication and collaboration skills, and which at the end of the day creates adoptable and practical lawyers in the workspace.
Our methodology has included desk research on CLE and KSL regulations, comparative studies of regional and global models, analysis of Strathmore's policies and practices, key informants from faculty members, and thematic analysis around impact, feasibility, and regulatory gaps. This hybrid approach allowed us to identify practical and policy-level pathways forward towards accreditation and provided nuance that would be explored in greater depth within the paper.
Our research questions and objectives focuses on 3 main things. Which forms of experiential learning would work best to enhance competency and preparedness among lawyers? Which gaps exist in the existing programs that are already there? And how can institutions practically integrate accreditation in the existing existing programs that are there?
Our conclusion is clear. Experiential learning is no longer optional for modern education. We are in a world that is changing too fast for us to still be governed by practices that have occurred statically. we recommend that the CLE would recognize and credit experiential components in accreditation standards, support universities in embedding structured practical work within core courses, promote supervised clinics and community legal work as essential learning spaces, and it would align East African legal education with global standards while preparing practice-ready lawyers able to serve communities effectively.
To conclude our presentation, we'd like to emphasize that our presentation is largely on a broad focus rather than what exactly our paper focuses on directly. It provides a broad focus that leads to discussion-oriented line of thinking, whereby we're looking at whether the issues that are present and the issues that are present are feasible to change. Whether there's a comparative framework, and whether there is need for regulatory restructuring in the program that is already there. So with that, we aim to push for a largely more experiential form of learning in the legal workspace.
And in the spirit of brevity, we conclude our presentation. Thank you very much.
Thank you so much, Jilo and Vishram. Please let us give them a hearty round of applause. They have exceeded expectations. I want to believe for past years, that is quite great. Hongereni sana. Let me welcome Jackie Mudhoni, who wants to speak on the issue of pedagogy. She calls for, our paper is on legal education and pedagogy reforms. So Jackie, welcome to the stage.
Thank you, and apologies for being late. I think the time factor, I thought I was presenting after the lunch break. Yeah. So thank you very much, CLE, for this opportunity to come and make my presentation. I don't know if it can be, yeah, thank you. So this is a topic that is close to my heart, primarily because as a faculty member at JQuad School of Law, Karen Campus, I have grappled and struggled with this issue since I became a lecturer. And I have had back and forth discussion with myself, and I'm glad that I'm having the opportunity to come and make a presentation on the same. So thank you so much for CLE for organizing this. So my paper is basically about calling for rethinking legal education in the competence-based era. And I am presenting a case. And my case is basically submitting on a case for structured pedagogical competencies for law faculty. In the program, I had written law lecturer, but I figured law lecturer is a categorization. So I want to lump everyone in, including the professors. So again, as you've been told, my name is Modhoni Mwangi, and I'm from JQuad School of Law, Karen Campus. And because I have limited time, 10 minutes to be specific, I'm going to skip some of the slides and go to the core of my argument. So at the beginning of this conference, we have had discussions about pillars of competency-based, and I will not exhaust what has already been mentioned, because when you are thinking about core principles, they have been mentioned. The core competencies in curriculum-based education have already been mentioned by the previous speakers beginning on Tuesday. But my focus is mainly on the learning approaches. How are we ensuring that learning is taking place? And when you think about competence-based education, we must ensure that we are practicing inquiry-based learning, we are ensuring project-based learning, we are ensuring problem-based learning, and self-directed learning. Now, when we think about these competence-based core principles, core competencies, and learning approaches, they have been developed by the Kenya Institute of Curriculum Development. But according to the Act, and specifically Section 5, the mandate of the KICD is limited only on basic education and vocational training. It therefore calls upon us as universities and specifically faculties of law to now think, how are we changing our law degree programs to ensure that they are competence-based? Considering we are transitioning as of 2029, 3 years from now, from 844 system to CBC, we'll be receiving students who are under the new curriculum. And for us to ensure that we have this, we need certain building blocks. And the first is that we must co-define the competencies, that who is a lawyer? What are the skills that the lawyer must have? And I've used the word co-define. So therefore, it is not the responsibility and duty of one school of law to define it. It is a collective responsibility. Why? Because we are channeling out students to the one profession, not different professions. And therefore, the definition of the core competencies must be done as a joint effort and a core effort. We must also design the core competencies. One of the key things about competence-based education is that we are moving away from summative assessment to formative assessment, progressively, continuously assessing the students, not issuing cut dates. Continuously, every lesson we are checking, is learning happening? We are not focusing on, I have taught, so I tick a box. Then we must mandate a pedagogical shift. We are in the 844 era. Most of us began our schooling in the 844. If not, we were in the 723 era. Now, we are coming into the competence-based era. Learning cannot happen the same way. Teaching cannot happen the same way. And therefore, at the heart of this is how we teach. Then restructure the degree program. Once we've defined our core competencies, once we have designed how we are going to assess, once we have empowered our lecturers on how to teach, on how to assess, then we restructure the degree program. Then it's not just about restructuring. Restructuring is a cost-intensive thing. Therefore, we must collectively, and here is where the CLE comes in terms of accreditation and regulation. Are you checking to ensure that you are issuing accreditation to institutions that have put up the necessary structures, they have spent the necessary resources, they have the necessary human resources to ensure that competence-based education is happening, not just by name, but by action. Then we have to embed a culture of improvement. There's something that's going on with the CBC, year 11, year 12, year 9, and there are a lot of complaints from parents that we keep on changing. Yeah, time is up. Okay. Yeah. So, oh my. Yeah. So summarizing in 3 minutes, when you think about the law lecturer, whenever an advertisement is made about a law lecturer, there are 3 core competencies that this lecturer must have. Qualification. 1 is subject expertise. 2 is scholarly expertise. 3 is teaching experience. My focus is on the teaching experience. How do we measure that this particular lecturer we want to admit in our university has the teaching experience? We usually ask, how many years have you taught? Do you have any certificate of service to prove the same? So my submission is that in the competence-based era, we cannot use time as a measure of someone's teaching skills, as a measure of someone's teaching capabilities, because then we arrive at several blind spots, which are systemic in nature. One is that time equals competence. We assume that the fact that you've been in school for so long, you have been teaching, then you are a competent teacher. We also assume that expertise, because you are a law professor in environmental law, you have mastered, that then it equals that subject mastery is equals to teaching mastery. That is a systemic assumption that we are making. The other systemic assumption that we make is that exposure equals to mastery. That because you have been exposed, you have attended conferences, you've published, that means you can be able to share this knowledge. But the challenge is you may be suffering from the curse of knowledge. And specifically, I don't know how many lecturers are here, and you have gone through a scenario whereby you are marking a card, you are looking at it, and you are seeing, the students have failed, but I taught this. So that means that you are suffering from what we call the curse of knowledge. You are not able to get down to the level of the students to see and understand that I'm not teaching them the same way a first-year student would understand. I'm teaching them at a higher level. So when you have those pedagogical competencies that are here listed, then you are able to... Let me finish with my recommendations. Okay. So those are the pedagogical competencies that are required. But then my argument is that we must have pedagogy both as a competence and it must be structured. Structured is the way we present it. Issues of legal framework, issues of policy, issues of evaluation, issues of... issues of... sorry. I'm under a lot of pressure. Yeah, so then how, the last, strategic roadmap for pedagogical excellence, what would it take? It would require we benchmark the goal, we benchmark how are other people doing it. After we've done that, then we develop master trainers amongst us who can be the trainer of trainees. After that, we develop the national legal education pedagogical framework so that we can be able to speak one language. So that when I come here and I talk about the backward design, I'm not talking to myself. Then...
It's all right. Please let us acknowledge Jackie.
Thank you so much, Jackie.
Let us stand up.
Thank you, Vishram and Jilo.
Can we all stand up and receive the Cabinet Secretary for Education? You can stay. Pick your bag. Let me hand over to the CEO.
The Honorable Cabinet Secretary for Education, Honorable Ogamba, the CEO, the Chair of Council of Legal Education, members of Council of Legal Education, Mr. Nyakundi specifically representing today the Attorney General and Solicitor General, and also being a member of the Council, Professor Sihanya, Dr. Helen. I am deliberate not to massacre her name, and therefore permit me to use the English name. Representatives of UNODC, Jennifer Githu and team, deans of schools of law, their students, their esteemed lecturers, and senior professionals in the academy, their distinguished lawyers, and importantly, we also have law students and new graduates of the law program. Good afternoon. It gives me great pleasure to welcome you, Honorable CS, to this conference. We have had a deliberation for 3 days around the future of legal education. We sought to have very candid discussions around the context in which the legal education infrastructure is currently in Kenya, looking back at how it has been, and also charting the way for the future of legal education in this country. We were honored to actually have very eminent scholars and personalities. We had, in the first day, the Speaker of the National Assembly represented to open the session. We also had Professor Kameri Mbote, Professor PLO Lumumba, Professor Sihanya, give us an overview of the status of legal education, having been the profession and looking back at how the situation has evolved over time, and also a reflection of where, from where they sit, they think legal education should develop and go. And we had very insightful discussions. We actually were very deliberate, especially for those of us who have been vocal of the direction that legal education has been taken in the country. There are those who believe, for example, that there are too many law schools, too many students entering into the legal profession that is not commensurate to the market demand. There are also those who feel the Council of Legal Education has been a tough tasking master, reasons being that we fail many of the students who attempt the bar exams, and therefore we noted that we sit at a very hard place, between a rock and a hard place, because then we have to balance between these interests. The aim of the council was to actually reflect on what needs to be done in the future of legal education in this country. So the conference convened legal stakeholders in the legal, regulatory, practice, and governance sector to deliberate on the future of legal education in East Africa, with participants from the judiciary, the Council of Legal Education, the Law Society of Kenya, academia, regulators, international partners represented by UNODC, and even the British High Commission. The discussions focused on quite a number of things, including the alignment of the curriculum to the demand of the time, the pedagogy or teaching of law, the regulation within the global trend, the technologies and transformation imperatives, including imperatives on ethics and on regional integration. Honorable CS, we had some key themes that I need to mention. The first one was curriculum reform and competency-based training, and we reviewed the shift to competency-based education, emphasizing what graduates can do rather than on what they know. We also looked at integration of experiential learning in moot courts, in legal clinics, in judicial attachment, and in service-based learning that must be formally recognized and accredited. Honorable CS, we also looked at interdisciplinary approach to the learning of law, and that required that we look at curriculum which must embed financial literacy, digital fluency, ethics, and emotional intelligence alongside the doctrinal law that we have often taught. We further recognized the prior learning as a critical component of the legal education, so that regulatory framework should validate skills and knowledge irrespective of where and how they were acquired. We also looked at training on public service lawyering, where skills required for lawyers in public service should be incorporated in curriculum for the training of the future lawyer. With the AI, blockchain, cybersecurity, and other online dispute resolution issues arising. We also looked at all how AI lawyer with the AI, blockchain, cybersecurity, and other online dispute resolution issues arising. We also looked at all how AI has transformed the sector in legal education with the enhancement that it has created, but also with the challenges that it creates. And it was noted that even though AI is a useful tool that we need to acknowledge, we also need to see the challenges because, for example, it does not have the emotional intelligence that the human faculty provide. So it was discussed that we need pedagogical innovation in the regulation of law that must adapt to students that are already using these AI technologies, for policing to guide and engage in the critical discussion. Excellency, CS, we also looked at the ethical and people-centered justice, and we said that the teaching of law now must not just remain theoretical, but must look at the ethics to integrate it. We also looked at regulation and quality assurance that needs to be then responsive. And there was a call to action, as I conclude, Honorable CS, and there were quite a number. We are continuing to prepare so that we can now document it, but there are about 10 or so very clear issues that were raised during these 3 days of deliberations. The first one being modernization of curricula to embed ethics, technology, and financial literacy, establishment of accreditation criteria that would would recognize experiential learning, harmonization of legal education standards, both regionally and internationally, with a recommendation for adoption of regular meetings with deans of schools of law in Kenya and in the region to just continue on that discussion. There was a recommendation for strengthening of quality assurance mechanisms in legal education to ensure competency. It was also recommended that we develop policy that are clear to define the legal education at university level as well as the postgraduate level, so that we review and reflect on what we have already been teaching and what then needs to be taught. There was also clear recommendation for development of policy that clearly defines the legal education standards and the structure, especially with the coming of CBC, so that we know whether a law program should now be 3 years or 4 years. There was deliberation on the possibility of allowing other institutions to offer advocate training programs, and there was a recommendation that we review the structure to ensure that that would not be something that would further lower the standards of legal education. There was also a recommendation that we must provide leadership by taking initiative to uphold the mandate that has been conferred on CLE by leading and following up on actions, including the recommendations that have been made in this conference. There was a recommendation for collaboration with the bar associations with a way of addressing the problems that have been identified, and to increase sensitization of the legal education structure and framework in the country. So, Honorable Cabinet Secretary, we have indeed had a very active and lively discussion. Let me just point out that we were very deliberate. We invited practitioners who have expressed their views publicly, maybe in social media, and we were not going to gag them. We wanted to have a sit-in on a table where we can agree that if there is a challenge, this is the challenge that we should address. And we also recognized that these people we are training, our children, they have gone through schools, they have gone through universities, they have been tested in the ATP program, and they have, most of them, qualified before they are admitted. In fact, my lady, the Chief Justice, was very keen that if the question that we must address is quality, we should not conflate it with the issue of numbers. That we must be able to address the concerns of quality, because if we have quality in legal education, then even the market itself will benefit from that quality, because we are not yet there. So with those remarks, I want to invite Professor Collins Odote, the Chair of Council, to acknowledge the representative of the Attorney General, and also to welcome the CS. Thank you.
The Cabinet Secretary for Education, the Honorable Julius Ogamba, who is also my friend, Mr. George Nyakundi, representing the Office of the Attorney General, representing the Solicitor General, who we had invited to come today, but also holding brief for the Attorney General. Ladies and gentlemen, all protocols observed, good afternoon. I stood here 3 days ago as we started this conference. So it's a great delight that we end today. And as we do so, the CEO has highlighted the conversations that we have had throughout the entire period. Conversations that show that this conference was timely. It provided us with an opportunity to reflect on where we have come from as a profession, to reflect on the kind of education we provide, and to ask ourselves where we need to go into the future. Cabinet Secretary for Education, your invitation to this meeting was deliberate and your attendance gratifying. You have the unique role of being a member of the legal profession. Therefore, you understand the challenges, the opportunities, and the need to have a conversation into the future. But in your current role at the CS for Education, there are 2 or 3 critical things that make your presence even more timely. You currently lead government efforts in implementing the competence-based curriculum. That competence-based curriculum has huge implications on legal education. Because by 2029, when those graduates enter into university, when those learners go to university, there are different kind of learners. Learners that have been educated in a system that focuses on competence, not outcome-based. Learners that are technologically savvy because of IT. Learners that are ethically grounded. Therefore, for us as legal educators, we must ask ourselves, what do we need to do to prepare for those learners? So that we do not find ourselves in a situation where we say, after we get them out, that somebody moved our cheese. Because then, as we discussed yesterday, we might, if we're not careful, be preparing learners for the practice of yesterday when the world requires the practice of the future. So that linkage with CBC and what it means for our curriculum, what it means for our pedagogy, what it means for our assessment as opposed to examination, and what it means for our role as trainers becomes extremely important to hear your sentiments and to be able to join with us. But secondly, something we've discussed during this conference, for very long in this country, Cabinet Secretary, there's been tough wars between professional bodies and the Commission of University Education that sits within your ministry. As we move forward to focus on the future of legal education, we must move forward in a manner which is much more collaborative and less conflictual. Because when we fight, we do not get the space to address the fundamentals that we require to address. And those fundamentals is the quality of education generally, and therefore the quality of education for all the different professionals. I am glad, though, to note, Cabinet Secretary, that as you come here today, you have provided leadership in efforts to try and address that concern. Members here may not know, but several months ago, we had huge discussions between the role of Q and the role of CLE concerning live cases of accreditation, as opposed to taking the normal treaded path of conflict. We took the path of collaboration and solution building. And you convened a meeting, CS, of ourselves, of Q, and of the concerned entities. What is interesting is, as a consequence, CS, we were able to overcome those issues. What is even more interesting is that overcoming those issues is leading to sustainable conversations into a future solution. And those were demonstrated a month ago by the CEO of the Council of Legal Education, Professor Jack Mumali, and the CEO of Q, Professor Mike Kuria, meeting on their own at one of their premises to continue that conversation. Yesterday, as part of this conference, the CEO of Q, Mike Kuria, was here to make a presentation. I remember one of the deans, and I don't know that she's here today, saying, Prof, I cannot believe that we can have a process where Q and CLE are together in a conference discussing the same thing. Thank you for leading us to that. And I said, that is the kind of country we should live in, where entities don't have tough wars, but instead they engage in addressing the intractable challenges that our education faces and our country faces. Because when you focus on those challenges, you find solutions. And I thank you, Cabinet Secretary, for supporting and leading that effort. Colleagues, as we end this conversation, the task ahead is extremely clear. The task of ensuring that the 10 recommendations that you've made at this conference are taken forward. I can just commit on behalf of my colleagues at Council, and I will request them just to stand up in 1 minute. Council members. So I would like to commit on behalf of George Nyakundi, on behalf of Mr. Eredi, and on behalf of Professor Lois Musikali, and on behalf of Sama Losa, please sit down, ladies and gentlemen, that as Council, we will take the recommendations that you've made seriously, and we will put all our efforts together with the Secretariat to ensure that they do not end here, but that they are translated into action. Because it's only then that we can ensure that the future of legal education becomes as bright as it currently is, if not brighter. Colleagues, allow me as I end to thank UNODC. Is Jennifer here? To thank UNODC and to thank Jennifer Guido, because the idea about this conference was started with Jennifer last year in April, when we were launching our strategic plan. And through her and through UNODC, they have been able to support us, although 1.5 years later, to have this critical conversation. And we're having a conversation with Francesco, and we had a commitment that we hope that this is not the last, it is the first, and that we can make this an annual conversation where we reflect and find solutions. Because they say when people sit together to discuss, they cannot have problems. Let me also thank the Secretariat of CLE. Please join me in giving a round of applause to Professor Jack Mumali and his team at the Secretariat for doing an excellent job in convening this and in leading us in the conversation. So Jack and team, we are extremely grateful to all of you. With those remarks, colleagues, I want to thank you. Please now allow me to first invite the representative of the Solicitor General, George Nyakundi, to read the Solicitor General's remarks. Then I'll come back to invite the Cabinet Secretary. George, please.
Thank you, Prof. If you may allow, let me write on the protocols already observed. Mine today is just to read the statement or the remarks by the Solicitor General, who was unable to make it today with another function, and he had scheduling challenges with his flights, so he was able to come, and he requested me to come here and read his remarks. Honorable CS, the Chairman of the Council of Legal Education, distinguished guests, colleagues and partners, ladies and gentlemen, good afternoon. I'm delighted to join you this afternoon. As we draw this important conference to a close, I would like to express my sincere appreciation to the Council of Legal Education and to all stakeholders who have contributed to the depth and quality of our conversations over the past 2 days. Your commitment, insights, and engagement in this conference reaffirms that the future of legal education in Kenya is in capable hands. This conference could not have come at a more opportune time. Kenya's legal landscape is undergoing profound transformation, driven by technological advancement, cross-border transactions, evolving dispute resolution mechanisms, and increasingly complex governance demands. Our courts, public institutions, private sector, and communities are encountering legal questions that were unimaginable a decade ago. In such a dynamic environment, we must ensure that our legal education ecosystem does not merely keep pace with change, but actively anticipates it. The conversations we have had here about innovation, curriculum reform, quality assurance, and global alignment are essential to position Kenya not only as a regional leader, but as a contributor to global legal thought. We have also been candid about the challenges confronting the sector, including the gaps between academic training and practical competencies, the uneven quality among training institutions, the pressure of regulatory bodies to maintain standards in an expanding education sector, limited integration of technology, and emerging areas such as artificial intelligence, data governance, climate law, fintech, and digital trade, and the rising costs and time burden on students seeking to qualify. These challenges are not unique to Kenya. They mirror global trends, but require local solutions. The deliberations and recommendations from this conference provide a strong foundation for those solutions. By interrogating our curriculum, reviewing institutional capacity, reimagining modes of delivery, and exploring best practices from comparative jurisdictions, we are better positioned to craft a legal training framework that is modern, responsive, and sustainable. The Council of Legal Education will now have the benefit of collective wisdom to strengthen regulatory standards, and training institutions have clearer directions on areas of reform. Ladies and gentlemen, looking ahead, our vision must be bold. We must envision a legal education system that will produce legal practitioners who are globally competitive and locally impactful. Legal practitioners who are not only conversant with the laws and precedents, but who can navigate digital platforms, understand data governance, advise, appreciate cross-border commercial realities, and apply multidisciplinary approaches to problem solving. We must promote lifelong learning, recognizing that the law evolves rapidly, and legal professionals must evolve with it. Continuous professional development should be a norm, not an exception. Legal education must remain anchored in ethics, integrity, constitutionalism, and service to the public. As Kenya strengthens its governance and justice systems, our legal training must produce principled practitioners who safeguard the rule of law. The future we seek cannot be achieved by any single institution. Regulators, universities, law schools, the judiciary, the Office of the Attorney General, the Law Society of Kenya, and development partners all have a role to play. We must encourage dialogue between educators and employers so that training reflects real market needs. We must engage international partners to benchmark global standards while tailoring them to our Kenyan context. Ultimately, our collective responsibility is to strengthen the pipeline that produces competent, ethical, and forward-looking practitioners. In conclusion, the outcome of this conference will inform policy legislation, regulation, and institutional practice. As the Office of the Attorney General, we stand ready to support and to work with each of you to ensure that legal education remains a pillar of national development. Let us leave here energized with the shared commitment to align our curriculum, our institutions, and our vision with the emerging global needs of the 21st century. Thank you, and I look forward to continued partnership as we build the future of legal education in Kenya. Thank you. That's the speech of the Honorable Solicitor General. Thank you.
Thank you very much, George Nyakundi. Please pass our extreme gratitude to the Solicitor General. And ladies and gentlemen, please give another round of applause to the Solicitor General. As I invite the Cabinet Secretary colleagues, I forgot that please join me in congratulating our colleagues who have just been appointed, who have just been nominated to be conferred with the highest title in this profession of Senior Counsel. I think 3 of them have been here during the time that we've had this conference. No, actually 4, if the ones that I quickly can't remember. I remember Elisha Ngoya has been here. I remember Dr. Koki Muli has been here. I remember Dr. Thiankolu has been here. And I remember Nelson Harvey has, since you went on leave of absence, Dr. Thiankolu, you have grown different. You have grown rounder. So I do not recognize you. And I also remember Elisha Ngoya. So please, not Elisha, I also remember Nelson Harvey. So at least those are the 4 that I remember. Huh? Oh, and yes, Chair, Kenya Law Reform Commission, Ms. Christina Gimba, very well deserved. So extremely grateful that that we've been able to share an opportunity with those colleagues who've just been awarded senior counsel, the highest title you can get as a lawyer. Ladies and gentlemen, without much ado, please join me in welcoming the Cabinet Secretary for Education, Honorable Julius Ogamba, to officially close the conference for us. And we can do what we know we should be doing, which is the Obama clap until he arrives here. Thank you very much.
Thank you, thank you. Please be seated. The chairperson of the Council of Legal Education, Professor Collins Odote, who looks very young, but let me inform you, or let you into a secret that is a very old man, having taught me in 2005. And partly responsible for my being here today. Because in 2005, when I wanted to join politics, I had to take a program called Political Leaders Development Program under the Friedrich Ebert Foundation, and he was a consultant there. So he taught us in 2005 to do politics, which has led us to being here today. But we are very grateful to you, Professor, for what you've done and what you continue doing. The Chief Executive Officer of the Council of Legal Education, Professor Jack Mimali, the Chairperson and Chief Executive Officers of all regulatory authorities and bodies here present, distinguished ladies and gentlemen, colleagues, good afternoon. Good afternoon again. I know it is almost time for lunch, so I'll be very, very brief. And want to start by just saying that I'm grateful for this invitation because I feel that I'm among friends. I've seen a lot of my friends here. Professor Sianya was my classmate. Dr. Alosa, who we were in the trenches together. And when I saw him downstairs, I just started missing what we used to do because we are doing something completely different. This conference is both critical and timely. It is critical because it has provided all of us with the opportunity to reflect on the landscape of legal education in Kenya. As we gather here today, the landscape of legal education and practice is not what it used to be years back. There have been changes and developments driven by technology and other emerging dynamics and opportunities such as regional integration and globalization. Contemporary issues like climate change have also created new openings and imposed fresh demands, not just on the legal practice, but legal education as a whole. It is befitting, therefore, that we have had the opportunity to gather here and to reflect on these issues so that we can chart a considered path forward. Ladies and gentlemen, I am pleased to be here, not just as Cabinet Secretary for Education, but also as a practicing advocate. These two hats give me the opportunity to share my perspectives, both as a policymaker in the education space and a legal professional who has watched the trajectory that the legal education and the profession has traveled over the years. As Cabinet Secretary for Education, I have to mention that one of the key matters that we are now dealing with as a sector is a reform of the education system. As you are all aware, we are now transitioning from the 844 system to the competency-based education system. Indeed, the pioneer cohort of this new system will join senior school this coming January 12th, and this group will start their tertiary education and training, including in legal education, by the year 2029. The new education and training system is focused on building and strengthening learners and trainees' competencies. We wish to shift from the education system that is theory-based and exam-driven to the one that is focused on holistic education and on imparting appropriate skills and competencies on the learner to prepare them for the life in the 21st century. And here I just wish to inform the team here from the universities, who I work with very closely in both good and bad days, Professor. that the competency-based education students, the cohort that is going to join the university in 2029, they are not your normal students that you know. And we've also warned the senior school teams that the students joining next year from the competency-based education, they are not the normal students that we know. They are not the students that will sit back and wait for you to tell them what the truth is, and that the lecturer or the teacher is not the only depository of what the truth is. They will challenge you. They'll demand that you engage them in various ways. They'll be ahead of you sometimes, and you have to be ready to have discussions and to debate with them. So it is important that as we move forward, as we look at what needs to be done, we start preparing early and understanding them. Even for those in leadership, for those who think that the Gen Z are a serious group, this new group that is coming, the Gen Z will look like Sunday school. They've been taught in a way that is almost 360 degrees. Even the way they sit in class, they sit perhaps the way you are sitting here, and I encourage you to visit some of those schools and see the way they are doing these things, so that the information is not coming from one place and moving into the other direction. So we need to be prepared early enough to be able to engage them in order for us to ensure that they are getting the very best and you are being able to do your very best. One of the primary duties that educators and regulators now have is to prepare adequately for the instructions and introduction of the competency-based education and training at the tertiary levels in readiness for the first cohort in 2029. We have to think carefully of how we will align legal education to the requirements of the competency-based education system. Essentially, our task is to reorient our legal education from the content-heavy to skills-based experiential and problem-solving pedagogy. There is need for emphasis on critical skills and competencies such as legal writing, advocacy, negotiation, decision-making, ethics, and digital literacy. This reorientation, ladies and gentlemen, will require a number of elements from legal education stakeholders. For example, to foster experiential learning and promote the acquisition of skills, we will require to build greater and stronger linkages to industry, the marketplace. There is need for our trainees to acquire the skills and competencies that the market actually demands. Mismatch between education and training on the one hand, and the demands of industry on the other, may make our graduates completely irrelevant and incapable of rising to the occasion. Going into the future, therefore, the legal education and training model has to be designed in a way that builds adequate synergy with industry. In the TVET sector, for example, we have promulgated the dual training policy and the recognition of prior learning policy, which establishes a framework for training both in academic institutions and in industry. Linkages with industry will not just help our students to acquire the skills that are on demand. Such linkages will also help academic institutions to determine the skills and competencies that the market requires at present and going into the future. Ladies and gentlemen, the other key aspect, which I have no doubt you've reflected upon, is the place of technology, given the advances in digital transformation, the emergence of artificial intelligence and machine learning. And here on machine learning, for instance, the KJSEA exams that we did just recently was machine marked. And that's where we are going to be able to release it this coming week. So there's a lot of technological advancement that is taking place in that space that you need to keep up with and reorient your programs to be able to tap into them. Technology has created a number of opportunities and raised challenges which we have to surmount by preparing our trainees appropriately. When, for example, I started legal practice over 30 years ago, the concept of virtual courts seemed a distant idea. I mean, it was not something that would consider. In fact, those who started practice those days, Professor Sianya, you remember, when we were applying to be, to be empaneled somewhere, we would start by saying, we have a computer. We have one computer, or we have two computers. We have a department that, that was something that would be considered when you are being looked into whether you have capacity to handle certain matters. Now that is like a thing of the past. Currently, even filing those days, without the physical stamp of a document that is stamped, you would not imagine that this document has been filed. Now that is not the case. So some of these things, when you look at them, and for those who are younger in this room, they look like a joke. But we had to do this because progression requires that you start from somewhere as you move forward. For example, we had to search, copious volumes of law reports to get authorities. Physical searching. Now you just go in there. If it is something to do with the titles you want, you just type and then something comes and you can look at the question that you need to resolve, and maybe within half an hour you've sorted what you needed to do. So the fact that these things are now readily available at the press of a button, also indicates that progression, and in future it is going to change. So you must be ready to see what's really likely to happen in another 10, 15 years, because now the technology is changing that much faster. I understand from my kids that in the West, something is being done to your glasses, that maybe all the data or information will be in your glasses, and you'll be able to say, I want to do something, and then it just comes through. So the legal education and training of today must therefore inculcate the correct digital competencies to prepare trainees for technology-driven world of work. Digitalization and digitization means that many sensitive documents, for example, and data are now online. The challenge, however, is that the increased exposure to cybercrime and the violation of data protection requirements becomes a reality. So it's something also that you have to start thinking about. How do you deal with that aspect, and how do you deal with the issues relating to the protection of data and privacy? Our education and training should therefore empower trainees with appropriate awareness and capacity for this new context. Another issue relates to increased cross-border trade and regional integration that have created demand and opportunities for cross-border practice. This is a time that we have to think of our legal education as being not just for Kenya, but for the region and beyond. We must prepare our graduates for practice beyond our borders, but also create an environment that is attractive to trainees from other jurisdictions. In other words, let us think of how we can seize the available opportunities to grow ourselves into a legal education and training hub. One of the challenges that I've thrown to the universities is some countries survive in the universities through fees or tuition that is by foreign students. Can we grow, our programs sufficiently to attract students from other jurisdictions so that we can sustain our universities, because the exchequer is growing that much lender as opposed to before. So these are things that we need to think about as we are dealing with issues to do with legal education. These developments, ladies and gentlemen, and emerging areas also mean new areas of legal education and training. The renewed focus on climate change and environmental governance means that the legal education has to be repurposed to equip trainees in the new areas. The same is the case for other areas like artificial intelligence, maritime and blue economy, data protection, extractives and natural resources, as well as regional integration. I will not purport here today to provide a comprehensive prognosis of legal education and training at this moment, partly because of time and largely because I am sure that you've robustly considered this and more issues in depth during your discussions, as the CEO here indicated. All I hope for is that the outcome of this conference will be a firm call for action, so that together we can build a legal education ecosystem that is fit for purpose and future ready. The onus is on all of us as policymakers, as regulators, professional bodies, practitioners, and educators to revamp our system and ensure that it works for everybody. And we must face the challenges and get solutions. One of the issues that you will find in this country, now speaking as a government official, is that we have Kenyans who are so good, very sharp, very intelligent in stipulating the problems of the country. They are experts in indicating what the problems are. We have very few Kenyans who are getting into that space of creating solutions to those problems. And we need more of those. And we need your training and programs to be tilted towards producing graduates who are problem solvers, as opposed to people who are ready to define and describe the problems that we have. On behalf of the Ministry of Education and the Government of Kenya, I wish to assure you of our support to the extent necessary and possible in building an enabling policy and legal environment to implement the resolutions that you have arrived at in this conference. Ladies and gentlemen, with those many remarks, it is now my honor to declare this conference officially closed. Thank you for listening to me. Asanteni sana, Mungu awabariki.
Thank you, the Honorable Cabinet Secretary. Permit me to give the vote of thanks as we close the session on behalf of the Council of Legal Education, that is the board and the management and staff, and on behalf of our partners who partnered with us to organize and run this conference, that is UNODC. We would like to thank the following for being there. First, for gracing the occasion, we want to thank the Honorable Chief Justice for gracing the occasion yesterday. Chief Justice Martha Koome, also President of the Supreme Court, and she's also Chair of the National Council for Legal Reporting, which was also a very strategic partner in this conference. Thank you very much. We want to thank Parliament, specifically Honorable Peter Kaluma and Honorable David Ochieng, who also graced the occasion on the first day. We also want to thank the strategic partners. We want to thank Rose Cave, who is the Deputy High Commissioner of the British High Commission. She gave the opening remarks on the first day. And Francisco Chechi, who is the Africa representative of UNODC. Thank you so much for gracing and sitting through and also working with us on this conference. We want to thank the chair of the board, Professor Odote, and the members of the board present and those who are not present. They've been very supportive and they sat through and walked with us on this journey. We want to thank Gitobu Imanyara, Faith Odhiambo, the president of the Law Society of Kenya, regional faculty representatives present from University of Makerere, the Law Development Center, and University of Dar es Salaam, and those from abroad. I think there were two of them. Forgive me for not remembering your names, but we are grateful that you could join us for this conference. We also want to thank the notable law professors who are here. I can think of Professor Sihanya. There are quite a number, Professor Dean of Tomboya, and other deans who made time to be present for the entire conference. We thank the CEOs of government agencies. I remember we had the CEO of Q, Mike Kuria. We also had the CEO of NCIA, among other CEOs. If I don't mention your name, just feel thanked for gracing the occasion. I want to thank Jennifer Gidu. She's really been instrumental in this conference. And thank you so much for guiding us and for helping us and for sponsoring the event. Panelists, presenters, members of the bar, including the Vice President of the Law Society of Kenya, we thank you for your presence. Moderators as well, thank you so much for agreeing. Most of you are called on a very short notice, and we are grateful that you could create time to come and moderate sessions. We don't take it for granted. I want to thank the attendees who came. I've seen some of my students, those who've just sat exams at the Kenya School of Law. We wish you all the best, and thank you for joining us. Want to thank every participant who attended. If I have not mentioned you specifically, please feel thanked on behalf of the council. We also had sponsors of certain events and certain activities. Jubilee Insurance, thank you. National Bank of Kenya, National Council of Law Reporting, Kenya Law, Law Africa, and KCB. UNODC deserves a special thanks for partnering with us. This would not have happened without them. We thank you so much, and we look forward to future events of the same. Staff management of CLE, thank you for the work you've put in. The hotel, the press coverage, and everyone else who's involved in this event, we thank you so much. I request that we stand for the national anthem. There was a request for photograph sessions. I don't know, with the guidance of the CEO, whether we will do the photography. Yeah, okay, so we'll do the photography of the national anthem, so we can have the national anthem and the East African anthem.
Mungu nguvu yetu.
Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tulilinde, tuajibike, tuimarike, umoja wetu ni nguzo yetu.
Thank you very much. We can have a photo session. I would request the CS, the chair, and members of the board. We can have the first. Yes, just here. Members of the CLE board can take the first. We do it. Okay, that. All right, no problem. We will move all of us outside at the steps. We'll take a group photo. Thank you so much.